Your Lordships kindly may I pay for your Lordships kind leave to move an urgent unlisted motion.
Urgent?
Unlisted motion, my lord.
Unlisted is gone, long over.
My lord,
What is it?
urgency is this, my lord. At any time I may be evicted from my food stall in the station.
Surface proceeding?
No,
Then?
proceeding. In the railway Messenger station, that my lord, the food stall has been allotted by conclusive contract, show cause issued with the allegation conclusively that my experience has been false, although it has been verified to be genuine from the author of the certificate.
Yes.
Now, my lord, without keeping the show cause proceeding pending, they are not going to, my lord, issue, my lord, order of termination of my contract.
The order of termination has not been passed?
At any time, my lord, because
the only show cause stage.
Show cause, my lord, it has been kept pending, my lord, for, my lord, at least 15 to 20 days.
15 to 20
my lord,
days.
No,
you please file it in the department, give the number.
11th, my lord, I have come to learn that some similarly circumstance, my lord, contract has been terminated, and at the same time, their stall has been, my lord, taken possession forcibly by RPA personnel.
Yes.
That is the question.
Today, absolutely no. You come back on Monday?
My lord, only thing is, my lord, if, my lord, the position is taken, my lord.
No, nothing will happen. 15 days you can wait.
Another thing, my lord,
No.
if I, my lord, serve the notice, I will be evicted.
You want to move an ex-party matter? Sorry, sir, I am not inclined.
Then it may appear, my lord, it may appear
No, sorry.
on Monday, my lord.
Monday.
Port Blair bench, my lord. Leave to file a writ petition of Group 9 of Port Blair bench, my lord.
Why the bench will be there?
Bench is not available.
Till the day before yesterday, the bench was there.
No.
What? No. Monday the court was there.
Before the till last week there was a bench, my
Till
lord.
Monday there was a bench.
Before the
Today's Tuesday. Wednesday.
Justice Jason Gupta, where the criminal matter are taken, my lord. Today there is no bench, my lord.
What is so urgent?
Urgent is the Group 9 matter, my lord.
What is the urgency? You can wait till the bench circuit sits.
My account has been freed, my lord.
Nothing. You, as and when the bench will be there, you please file it.
My lord,
Yes.
Withdrawal, my lord.
Yes, give.
My lord, item number 264, my lord, the urgency is, my lord, there's a termination, rather, my lord, cancellation of the tender on 30th of July. And, my lord, I have filed the writ petition immediately. Urgency is my performance guarantee is going to be, my lord, withdrawn. My lord.
Invoked.
My lord, this is a railway contract for installation of solar plants. They were insisting of using of domestic cell.
Whatever. The
So, Lordship, here's the matter, my lord. I, in fact, want to do the work also. My allegation
that is different. But then the matter has to be heard.
Yes.
Tuesday.
Give notice and come.
Tuesday.
I'm obliged.
My lord, I am representing a 4-year-old girl whose passport has been denied by the passport officer. You had upgraded it kindly. But then it needs an urgent because the Puja holidays are only 6 months and 6 weeks away. And tickets are not available anymore. They want to go abroad.
They'll go during the Christmas vacation. Do not worry.
May I permit to mention the last on 6th August, I moved an application regarding supply of certificate copy of deed. When your lordship, please certified copy of deed, my lord.
Yes.
So when your lordship was pleased to ask me to supply the order passed by your lordships, which is I am covered by your lordship's order.
Oh, yes, yes. Right. Then
May I have a leave?
Is it not appearing? It is there in the...
It is in the combined list 203.
203 in the combined list? All right. It will appear tomorrow. Give notice to the other side.
May I have...
My lord, may I have a lordship's leave to move an urgent motion, my lord? My lord, admittedly a government road according to the Porcha, my lord. Now, my lord, 144 code directs the Panchayat to initiate a proceeding under section 23. Panchayat initiates a proceeding under section 25, but my lord, it is a government road. And my lord, it admittedly falls within the Act of Public Premises Unauthorized Occupation Act. And now, my lord, Panchayat has given me a notice of eviction, of demolition today itself, my lord. But
go before the Panchayat bench.
my lord, it doesn't relate to Panchayat, my lord. The Porcha itself shows, my lord, it is a government road, it's a collectorate road, my lord.
Maybe, but the impugned act is of the Panchayat. Why don't you move the Panchayat bench?
My lord, it doesn't relate to the Panchayat, my lord. Kindly see one document, my lord, the Porcha itself.
That is a very good ground to go before the Panchayat bench and say that it doesn't relate to the Panchayat.
My lord, today the demolition will happen, my lord.
Yes, if you can come before the Group 9 bench, you can go before the Group 5 bench also. Where is the difficulty?
Here's it, my lord, because both the courts have determination, my lord, because this land itself is a government road, my lord. Land itself is a government road, my lord.
Where is the matter?
My lord,
You want to move it? All right. Tuesday. Serve.
Lord,
Take
Monday
leave.
kindly.
All right, Monday.
We have, my lords, kindly if to mention a matter, my lord, an original side writ petition for inclusion.
For hearing.
For inclusion, no, motion.
Original side court applications will appear in usual course.
I just.
May I have my lords kindly if to
Yes.
mention a matter, my lord. This is, my lord, my tenure was cancelled on 20th May.
What do you want?
My lord, this is an urgent motion, my lord. I am the L1.
Urgent motion. Where is the matter?
My lord, matter in the mandamus section, my lord. The matter was moved. before the-
Mandamus section.
Yes, my lord. The matter was moved on 3rd June, my lord, 2025. The Asansol District Hospital was directed to give notice and come with the relevant papers, my lord.
Yes.
Thereafter, the my lord matter was kept on 5th June, my lord. It could not be reached, my lord.
Then it went to the mandamus section.
My lord, from the that is from the vacation bench, it has gone to the mandamus section, perhaps, my lord, because it was moved from the vacation bench, my lord.
It was moved during the vacation.
Yes.
And now we are in August. All of a sudden, the urgency has
My lord,
cropped up.
because my lord, the tender was cancelled, my lord. It was resolution was obtained on.
It was cancelled in June.
My lord, it was
Thereafter,
cancelled,
so many inclusions
my lord,
were taken
my
up.
lord, it was
No,
cancelled, my
sorry.
lord, it was cancelled in July, my lord.
Yes.
20th, there was a resolution, and
Yes.
L1 can
All said and done. Today is not the
my
day
lord,
for
if this
inclusion.
can be taken up at any time. my
Sorry,
lord.
sir.
My
Yes.
lord, my lord, kindly, my lord, if this can be
Sorry. Yes, please.
Madam, may I have lordship to mention RG number 12,135 of the common list, madam.
No, today is not the day for mentioning.
Very urgent, madam. My salary deducting, madam. At least
You should have mentioned it on the day of mentioning. Every day it will not be done. Yes. What is the matter?
My lord, I beg to mention 3 applications. 1 is for restoration and 2 is for upgradation.
Come on the day when inclusions are taken up. Call the list.
May it please your lordship.
Yes.
Appear for the respondent. Please your lordship, sir. By your lordship's last order, the lordship had directed the insurance company to provide us with the documents. We inspected and we have, my lord, taken photocopies of those documents, my lord. But we have received it last afternoon. So, my lord, I would beseech your lordship, since there is another connected matter where the same exercise has to be taken up, that is this item number 2, my lord will kindly keep the first item also running in the list for the only reason that we just need to check whether we have received all the documents or not. But yes, in most certainty, we must be receiving. It's in excess of 3,000 pages, my lord. We just need to check it and confirm.
Item number 2 also same order will
Yes,
go.
my lord, with your lordship's leave, may I, my lord, kindly hand up. I've just made some small corrections in the first order, which can be a verbatim of the second matter. Can be the same.
First order, no correction is required.
No, first order, my lord, we have complied with your lordship's direction. It is related to one policy. Second matter is related to another policy.
Which is
All right.
Same order will be
first time.
passed, but the policy number will be changing.
All right.
Yes,
Separate order has to be passed.
I have indicated that.
Dekhi,
Only
in
the
the
date and date has to be changed for.
and the first in the second matter, it's appearing for the first time.
Yes, yes.
Oh, acha. Second matter is appearing for the first time.
My lord, so I took the liberty, my lord, for your lordship's convenience, only
All
to
right.
indicate the small correction.
The policy number will change, otherwise things remain
The
the
date.
same.
Whatever date in which we have to comply there.
And the inspection that you have taken, is it in respect of this policy also?
No.
Because the documents was earlier policy.
Documents were in relation to the earlier policy. So the returnable date will change. Right? It is 24th of July.
You can keep both the matters, my lord, after
All right.
midnight.
24th of July, it was made returnable on August. Today is 13th. 3rd of September.
Yes.
এদিকে আসুন এক মিনিট।
For this separate order.
First matter.
Separate order.
Yes, separate orders. First matter order লিখুন. Learned advocate for the petitioner submits that copy of the documents have been supplied to the petitioner.
May I hand over?
The petitioners হবে. The petitioners intend to revert with instruction. So, on such submission, release the matter on 3rd of September. ঠিক আছে? Next matter টা item number 2. এইখানে এই চেঞ্জেস গুলো হবে, রিট পিটিশন নাম্বার চেঞ্জ হবে, আজকের অর্ডার ডেট চেঞ্জ হবে, এখানে পলিসি নাম্বার চেঞ্জ হবে। এটা হয়ে যাবে 3rd of September. Item All right.
The instruction with regard to the first matter, we kept with record. my lord.
ও ইনস্ট্রাকশন দেখুন কে দিয়েছে, ডেট দেখে নিয়ে রেখে দিন রেকর্ডে। ইয়েস,
তোমাদেরই চিঠি, ঠিক আছে?
I'm deeply obliged, my lord.
But I'm appearing on behalf of the petitioner, Millet. Being led by a senior Millet, he's requested me that if your lordships will kindly keep the matter after the
ভেকেশন
20th of August.
নো পূজা
It's
ভেকেশন।
not, Millet. He's in some personal difficulty in the over the next 2 weeks, Millet. That's why he requested me, Millet.
Why not take it after the pujas? So is it so very urgent?
Millet, pertaining to a
We
willful.
declare as
The
people
order passed
doctor.
quite some time back, my lord.
Quite some time
Quite
back.
some time back.
But
And
it's
the
the
CBI
order-
came up on the last occasion. They said they wanted to make an application because I think they filed some charge sheet. Whatever it is, whichever day is convenient.
We
I-
give a copy of the writ petition to CBI Millets. My seniors there, Millets. He's asked me to make this request, Millets.
1st September is okay. That's a Monday.
Yes, it's okay.
On the prayer of the learned advocate made by the petitioner. Released on 1st of September.
Grateful, Millet.
Record everybody's appearance.
It is to name. Lordship, Mr. Ritik Chaudhary is on behalf of the petitioner. He is appearing in another court. Kindly make it short.
Well, I have indicated that
Yeah.
Lordship's bench does not have jurisdiction
Doesn't have,
because there is an eviction order passed and thereafter section 6 proceeding is going on against them for, well, they are not the tenant. They are not
6 of the.
Public Premises Act. An eviction order has been passed under the Public Premises Act. So, Millet, it should basically, Millet, go to court 17 because of the Public Premises Eviction Act and
Call your senior, I'm passing it over. The
Lordship.
bench doesn't have determination. Why hold on the matter?
Lordship.
Yes.
Grateful, Millet.
Next.
Item number 5.
Five, my lord, I am appearing on behalf of the petitioner, my lord. Virtually, my lord.
Yes, what is the matter?
My lord, matter relates to, my lord, payment of, my lord, interest on the
Who is
principal
your other
amount
side?
they have paid the. My lord, we have served because after service, my lord, filing is now only possible in original side. So, my lord, affidavit service is also deposited with the file.
Yes, it is deposited, but nobody is appearing for the other side.
Very well, my lord, kindly make it, my lord, next week, my lord, I will serve again notice, my lord, to them.
1 minute, please, 1 minute.
For the respondents.
Eastern Coalfields? Yes. Oh, yeah, the council is here. What is the matter?
My lord, matters, my lord, relates to, my lord, I have, my lord, done one job as per the NIT before the Eastern Coalfield Limited. Now, after that, my lord, they have, my lord, not paid the entire amount and they have, my lord, issued also, my lord, penalty upon us. We have paid the penalty. Now, the issue is for consideration at this stage for payment of, my lord, interest on the principal amount they have, my lord, paid after lapse of, my lord, 5 years. This is the issue, my lord.
So you want interest on account of delay?
Only interest on the, my lord, principal amount.
Yes.
It's an absolutely civil dispute.
What is the civil dispute?
Because Milord, whether his claim, Milord, is that the delay that was occasioned in the matter was attributable at our behest. That is why he is claiming interest on that delay. Whether Milord, who is responsible for that delay, but there is a mechanism provided in the tender document itself.
Where is it?
The document he has not annexed entirely.
You have a copy?
E-tender notice he has annexed. Milord, that is annexed in the writ petition, Milord.
Yes. Where is the provision?
Page 24. The entire mechanism is there. The arbitration clause is there.
Show me, please.
Yes, Milord. Milord, the Kaushik would find that this scope of evaluation is Milord at page 35. Milord.
No, show me the grievance redressal mechanism.
But that part is not.
Who is responsible for making the payment? Is the general manager responsible?
No,
making payment?
Manager is responsible.
General manager?
Well, actually, engineer in charge is the my lord, person. who is to, my lord, make the, who is to make the bill and to pay the
I
amount.
see there is a representation from the petitioner before the general manager.
Yes, yes. My lord, GM is
Let that be
head of the
considered. Let that
head
be
of the
considered.
authority.
Please come.
My lord, kindly, my lord, let them, my lord, file a report because they will consider and, my lord, reject, my lord, my
Then
application.
if there is a rejection, you can always come forward. No difficulty. Acha. The matter relates to a contract. Stop. The petitioner submits that. Acha, a contract executed by and between the petitioner and the respondent authority. Stop. The petitioner alleges that the payment in terms of the contract was dispersed after a long delay and the authority ought to pay interest for such delayed payment. Stop. A representation by the petitioner to the general manager of the Eastern Coalfields Limited is pending consideration. Stop. Prayer has been made to direct the respondent authority to take a decision on such prayer. Stop. Learned advocate representing the Eastern Coalfields Limited opposes the prayer of the petitioner. Stop. It has been submitted that there is already a dispute redressal mechanism mentioned in the contract itself, and the petitioner ought to have availed the said remedy. Stop. Paragraph. The learned advocate appearing on behalf of the respondent of the parties, however, are unable to produce before this court the proper procedure for dispute redressal in relation to the subject contract. Step paragraph. As it appears that a representation from the end of the petitioner is pending consideration at the end of the respondent authority, accordingly the instant writ petition stands disposed of by directing the general manager, being the respondent number
The general manager is
4.
4.
General manager civil it will be?
But that is the one, this entity is the one who, before whom the application was made. So that he has to, that response that should come from him.
Is directed to take a decision in the matter. Take a decision in response to the representation filed by the petitioner, strictly in accordance with the terms and conditions of the contract. After giving an opportunity of hearing to the petitioner at the earliest but positively within a period of 8 weeks from the date of communication of this order. Step. If any amount is found due and payable, the same shall be disbursed without any further delay. Step paragraph. It is made clear that this court has not entered into the merits of the claim of the petitioner, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation. Stop. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Writ petition disposed.
Well, only
My lord,
only
grateful to
two humble requests, my lord, if I make. But one is, my lord, lordship
My
can-
lord, one prayer, my lord, may I make, my
lordship
lord?
can-
If you lordships kindly allow, my lord, the also fresh representation, my lord, so that I can incorporate other, my lord, points, my
This
lord.
is what I was saying. Kindly limit, my lord, it, my lord, till the question of interest, because that is what he has, my lord, asked for from the court.
Yes, this is
But-
what has been
Yes,
referred
now-
only.
now
Yes,
that
yes.
has been
Only, my
made-
lord, I am praying, my
that-
lord, your lordships make also kindly give me liberty, my lord, to file and make a fresh representation, my lord.
Kindly do not allow this. That is my friend.
Where is the difficulty in the representation that is annexed to the writ
My
petition?
lord, there may be some, my lord, lack in the, my lord, representation. So that's why, my lord, I am praying, my lord, there may be a fresh, along with that, my lord, representation, I may be allowed to file
Along
fresh
with that, this will expand the scope of the representation.
Lord.
Whatever is
Or, my
there,
lord, your
make
lordships may direct,
submission.
my lord, fresh.
You make submission
lord.
over there, whatever you've got to say.
I'm not one last submission, my lord. If lordship kindly record my as my submission,
That it's a civil dispute.
Yes, alternative remedy, that point kindly record.
I have recorded that.
Great.
Get put.
বললাম না, it is a civil dispute, ওনার বক্তব্য বলেছিলেন।
Next matter is also same, my lord.
ঠিক আছে, আপনি পাঠিয়ে দিন, আমি দেখে নেবো। Yes, next 6 or same order,
Yes,
Same order.
same appearances.
5 and 6, same matter.
তারপর
Please, my lord.
হুম
Milods,
হুম হুম
my lords. Milods, we are the largest linen plant in the country today, Milods, perhaps the oldest. Milods, we kindly come to page 138.
oldest plant of
Oldest linen manufacturing
linen
plant is
manufacturing.
Rishra, Milods.
All right,
We are in Rishra, Milods.
Rishra.
Rishra in West Bengal, Milods.
Yes.
We are Grasim Industries, Milods. The plant was established way back in 1949, Milods.
All right.
Milods, by way of this act of 2025 at P24 138, page number 138. This is the Act, Milods, West Bengal Act 4 of 2025, revocation of West Bengal incentive schemes and obligations in the nature of Grants and Incentives Act of 2025. Milods, I'll just read the SOR very quickly. An act to rescind, revoke.
Yes,
Milods, I've already seen it, Milods. We were here on
right.
the 5th, Milods.
This has to be heard.
This has to be heard, Milods. This is a new, fresh petition, Milods. I am just requesting one thing, Milods. What has happened is, we have a lot of dues, Milods, through the West Bengal Industrial Development Corporation, Milods. They have already approved, and then partly they have also paid me the incentives. With the act coming into play in June, which was first gazetted, it's dated 2nd of April, but in June, they have stopped even considering me grant of any eligibility certificate or a sanction order, and which has been pending with them forever, Milods. And in fact, under the 2004 scheme, we have already invested, we have generated employment, we've also given revenue to the state, Milods, and the promise was that it will be paid back to us in certain percentage over a period of time. Today, Milods, we have outstanding of over 33 crores in one plant, Milods. 2 other petitions, Milods, which are, I'll give details a little later, Milods. We have 187 and about 55 odd crores to be recovered from the state, which has to come in a periodic fashion to us. Milods, may kindly see this page, Milods, 138 once. I will not take much time. Milods, we've already introduced this before. And Milods, what it further says in 4.4, 4.4 is at page 141. Notwithstanding anything contained in any other law for the time being enforced, no suit or other proceeding shall lie or be maintained or be proceeded with or continued in any court or before any tribunal or authority for claiming any incentive and or for payment and or refund of any incentive under any scheme or grants or obligations, and no enforcement shall be made by any court. This is the law, Milods, which they are making today, Milods. They have taken or deprived me of everything. And Milods, 3.1 and 3.1 at page 140, A, 1, 2, A and B, Milods. Prior claims, I'm not a B, I read first line, shall no longer be entitled to raise or enforce any future claims. Milods, at page 142, the list of schemes are there. These schemes came every 3 to 4 years or 5 years for the validity period. 93, 99, 2000, 2004, 2005, 2008, 2008, 13, 15 and 21. What it did, Milods, I've also annexed the scheme. The scheme said at least 17 kind of incentives will come to me.
Will come to you.
Will come to me if I invest. In fact, if I relocate from other state to this state for generation of employment, if I invest money.
Pursuant to which payments were made to you.
Exactly, Milods. And pursuant to which, Milods, I have to give them eligibility claim for eligibility certificate. They will verify it. They have given me sanction letter, which are also in place, Milods, on record today. They have paid back part of the money, Milods. Milods, may kindly see, I'm just going back. 127 is one of my last representations. 127, P17, 31.92 crores under IP. IP is, Milods, Industrial Promotion Assistance.
And Miller's SCIS in column 3 is State Capital Investment Subsidy. Miller's what happened is the state needed money. State wanted us. We are Miller's Aditya Birla Group. Flagship company is Grasim. We also have Miller's Ultratech here in the state itself, Miller's. We invest, they ask us to invest money, they ask us to expand. They sometimes also in the scheme say, if you relocate from other state and come in this state, you please generate employability. Miller's, we've already done all that. The certificates are in place of how much we have invested and how much employment we have generated. When time comes to Miller's pay back the money over a period of time, an act comes into play. This request, Miller's, I made in 18, kept pending all the way, and then Miller's P23 on 28/7/2023 at page 137, a group of ministers is constituted. A group of ministers is constituted to examine different issues related to various incentive schemes for large industries, like WBIS 2000, 2004, what I just read, Miller's, WBSSIS 2008 and 13, and make suitable recommendation for consideration of the state cabinet. GOM will have following members. And then Miller's in 2025, this act comes into being. It's completely contrary to constitution. It's ultra virus, Miller's. What we are seeking is this act has to go. Because till the time this states, Miller's, they are not even going to process anything. No claim will be processed. And Miller's, I'll be sitting duck, Miller's, for I don't know how many years. This they have, I have one solution. I understand, Miller's, this can't be done at a motion hearing, Miller's. All I'm requesting, Miller's, is that my request for sanctioning and eligibility can be processed in the meantime, subject to the outcome of this court, Miller's. Any order that can be passed. At least my file will proceed. Today, Miller's, any officer will look at this act, say, I don't have any power to process any request that I make.
Yes, Tilanadeji.
The Lordship has been pleased to consider a challenge to the same Milord statute on an earlier occasion.
Yes. There was an interim order.
Yes, there was an interim order because
I have that, Miller's. I will.
Yes.
There was a recovery
Claims of
proceeding.
recovery.
Yes.
My Lord was pleased to
Miller's
see that portion. Well, if my learned friends, I don't think my learned friends can have the same apprehension today because the eligibility certificate is yet to be issued.
We have issued also.
Yes.
In some occasions, they have been issued and some may be awaiting.
That's right.
So, but here, Milord, your Lordship, because I don't think my learned friends question the power of the state to legislate.
No.
So, therefore, Milord, it is not ex facie unconstitutional.
Miller's, we have, Miller's. We have taken those grounds.
Yes. Now, unless, Milord, your Lordships have held that unless a statute is ex facie unconstitutional, because if I can give something, I can also have the right to withdraw it.
At any time, when you give, there must be some reason for giving. It's not gratuitous,
yes.
Right?
No, it is gratuitous. It is gratuitous primarily to encourage.
And then you discourage.
Milord,
or what?
Milord, these are economic policies. Milord, economic policies, Milord,
So the state
do affect some persons.
Certainly it does, because you are promoting industry.
Yes.
And it is for the very purpose that these schemes were there. All on a sudden, when somebody has made or acted in terms of your promise, and
that is possibly not correct. That they have altered their situation.
They have.
Yes. Milord, on that matter, we'll make
This is
elaborate
what
submissions.
he says.
Yes, he says that, but we'll make elaborate submissions on that, Milord, once Milord, your Lordship takes up all these matters for hearing. But Milord, for the time being, kindly pass directions for affidavits.
Miller's, I'll just point out one thing, Miller's, just to respond to one particular. I didn't open the entire file.
Today, Milord, these schemes are no more in force.
That's the point. Yes. 62, Miller's.
Whatever he's asking is something in furtherance of the scheme, that is to issue the eligibility certificate. The Lordship may consider it at the final hearing stage.
And that is exactly the reason why the prayer that he is making cannot be accepted for proceed with the recommendation of issuance of the certificate. It cannot be done because right now the scheme is no longer there.
Miller's, I'll make that good. I'll make that good, Miller's. Miller's, may kindly see page 62, Miller's. I am just reading the 2004 scheme, page 62. At 22, Miller's. It's on the right-hand column. Power to amend and or relax when the 2004 scheme was brought into play, Miller's. What it said, notwithstanding anything contained in any of the provisions of the 2004 scheme, the state government may at any point of time make any amendment to this scheme or repeal. But
The
the commitments already
shall not be affected by
shall
any
not
of
be
the
affected. And Millers, my return has to come only after I establish that I have spent the money. Then I have to pay taxes. On the taxes that I pay, I get the subsidy, Millers. I will show one of the certificates, Millers.
But this has to be hard.
2018. I
Otherwise,
agree, Millers. It has
So
to be
this
heard.
is
I
another
understand.
point
This
which
needs to
requires
be
your
heard.
lordship's attention. Is that as my learned friend had uttered the last sentence that he had paid the tax. But under our law of our country, there cannot be any refund of tax.
not refund of tax, but the incentive he will
The
get on the
incentive-
basis of the taxes that
I'll tell you,
paid.
Lordship, Milord. The incentive is that you pay 100 rupee tax, you will get back, say, 90 rupees. Now, this, Milord, the Supreme Court from 1992 has said that there is no power to legislate even for refund of tax, legislate to that extent. Number one. Number two is, Milord, there is no promissory estoppel in regard to refund of tax. And most importantly is, Milord, as you Milord, there is a contract, promissory estoppel, whatever points are there in favor of the petitioners, Milord. At the end of the day, this is also a contract, Milord, which can be intervened or reopened, Milord, by a statutory provision. Otherwise, Milord, concluded contracts, your lordship have held that concluded contract cannot be reopened. It can only be reopened when, Milord, some statute steps in. Therefore, Milord, this is a situation we'll argue whole hog, Milord, all these things. But at the present, I don't think, Milord, there is any subject to your lordship's correction. Any scope of any interim order, we'll file our affidavits and come back. But these are not absolutely points of law or points of law.
Hardly there is any scope for
Right.
filing affidavit
Right.
because factually there is nothing to say. This is the point of law.
He'll say, I am entitled. I'll say you are not entitled. But Milord,
Yes.
finally, these are all points of law.
Right.
Whereas there's only one question, Millers, whether they can come out with a statute so perverse to take away all that they have promised me in the past and have acted under the policy. Yes, Millers, it has to be argued on Article 14, Millers. It's purely a question of whether this statute is manifestly arbitrary or not, Millers. My certificate, Millers, just to answer Learned AG's question, is already at page 130 and 133, Millers. So
I do not think there is any
I
scope
understand,
to
Millers. But these
pass any interim order either.
Millers may give a short date, Millers. Otherwise, Millers, what will happen is that nothing will be processed. It's not only in this case, Millers. Like Millers had already pointed on 5th of August, I was also there on that day, Millers. I traveled for that day. In the Birla Corporation order, Millers were conscious that there will be many petitions filed in this regard, Millers. And I think, Millers, I'm already in place with at least 3 petitions here, Millers. Millers, I would give just
When is the other one fixed?
Millers, I have the details of that, Millers. I come from outside, Millers. I have a small note on all those 2 matters also, Millers. I'll just say, Millers, what is the details. Detailing out how much we've invested, when is the petition.
No, these
They are on
matters in the appellate side.
Millers, before this court only,
Yes, this
16737.
court is all right, but in the appellate side.
Identical petition, Millers, we've only drafted it. Identical
petition.
prayers.
All right.
Anything,
No,
Millers, can be tagged up or can come up together. That's all I can request, Millers. I understand it's not before my lords right now.
All right. The order passed in the earlier matter, when is it returnable?
That is returnable, Millers. I have a copy of the order. 26th August, Millers. Millers, there is no next date, Millers. I think such affidavit shall be prepared.
Oh,
and
liberty
submitted
to
by
mention.
26th,
Liberty to mention.
By 9, open for the petition to file exception to the same by 9 September 2000.
When 9th of September, so it means it goes thereafter. Prior to the vacations, it's not possible. When
Can
do
you
I?
keep it after the vacation?
Obviously, it has to be after the vacations. 7th of November, I fix it. The first Friday after reopening.
Affidavit of service, do we have to hand over this?
Achha. Revocation of West Bengal incentive schemes and obligations in the nature of grants and incentives Act, 2025 is impugned in the instant writ petition. Stop. The matter is required to be heard. Stop. There is no scope for passing any interim order in the matter. Stop. List for hearing on 7th November 2025.
Because a reply could be filed in the meantime, the other side also, in the other matter also, will also mention.
In the event the respondents intend to file an opposition to the writ petition, comma, the same may be prepared and circulated by 10th of September, reply if any by 26th of September.
Please, Manoj. Manoj, would be pleased to tag the other matter also, Manoj, so that they can come together. It can be heard together and disposed of together, Manoj. It will be the same argument, identical. Here is Manoj. I missed the other one, Manoj.
Thing is, in the original side, this type of tagging cannot be done.
I see, Manoj.
Whenever this matter comes up, is it there in the list? In the appellate
in the
side list?
monthly list, I'm told, Manoj, at 1500 something, Manoj. Identical prayer, identical wordings. I only
Please tell your junior to mention it tomorrow morning or any time so that it can be.
We'll do that, Manoj. We'll do that, Manoj.
Put it in the list and necessary orders passed.
My lady, my lady. Grateful, Manoj.
হ্যাঁ ঢাকুন দেখি পাশাপাশি এসছে As this bench doesn't have determination. This is a submission.
My lord, I am being told that the original appellate side determination, my lord, the court number 17 has the appellate side determination.
Oh, original side determination is not there.
No, original side matter is there. Yesterday only I did two matters before that.
Check up the list. Please check up the list.
But kindly have a look, my lord, on 11th August.
17.
Yes.
Page 82.
17th. Well, Lordship will find both, my lord, under public premises and West Bengal Public Land Eviction Act. Both are with Justice Basu.
No, but then does Justice Basu have the original side determination?
Yes.
My lord, it is not.
See in the list.
My lord, it
It's
is not
not because
specified in
the daily he does not take. My lord, yesterday only I have done.
The matter is the determination is there.
Yes, I have done,
then
my lord.
If my lord has the determination, my lord.
It has been the matter relates to
Public Premises Unauthorized Occupants Act 1970.
This bench does not have determination to take up the same stuff. The same stands released from the list of this bench for want of determination. Stop. Let the file be placed before the bench having determination.
Lordship, I am grateful. Much
obliged.
Next.
Matter was being argued, my lord. We had concluded our submissions. The learned Advocate General, my lord, while my lord giving his reply, my lord.
Yes, any instruction that you have obtained?
Yes, my lord, I'll tell you, Lordship. I have the instruction. Well, what I had submitted is the instruction, but only one thing, my lord. The instructions are here to, my lord, put an end to the matter.
Without the court passing a judgment. It is only relying on this.
Yes.
It can
Well,
be.
I'll tell you, Lordship, but I had a point of maintainability whether, my lord, these parliamentary privileges and all that, my lord, are to be invoked over here so as to argue that the legislature being a coordinate body, whether, my lord, there should be any judicial review in regard to, my lord, the security arrangement. But your Lordship wanted to, my lord, cut the issue or, my lord, shorten the issue. But I've taken this instruction, my lord. Kindly have a look to this.
Yes.
WhatsApp করে দিচ্ছে. In clarification to your query, when this address to me, but kindly.
Yes, it's all right.
I am to state that before each session, each phase of a session of a house, a bulletin part 2 is issued for information to all regarding the security arrangements to be followed in the premises of so-and-so. The 17th Legislative Assembly was constituted on so-and-so, and the untoward incident which was reflected in the order of 6/5/2021 occurred on 6/5/21. At that material point of time, no bulletin part 2 was in force as the previous assembly was dissolved on so-and-so. Be it mentioned here that the entry of personal security of all members of the house, including ministers inside the assembly house precincts, is prohibited, and it has been published in bulletin part 2 from time to time for information of members. Some of such bulletins are attached herewith for your kind perusal. The order dated 6/5/21 was issued only because no bulletin was in force at that point of time. And after bulletin part 2 of 1/7/2021 was issued, the entry of personal security personnel of the members are guided by the bulletins issued from time to time to that effect. Be it also mentioned here that the reply dated 12/3/25, where this was referred to by my learned friend, was provided in view of the prayer of C. So-and-so, private secretary of so-and-so. In this connection, it may not be out of place to mention here that as per the bulletin part 2, armed escorts, PSO, of honorable ministers, members of parliament are also not permitted inside the parliament estate, a copy, etc. But that bulletin, I had is a part of my annexure. So, if it is set at rest at this, then we need not go into all the.
It is applicable for each and everyone, and it is not that the
X is,
political
X is allowed, Y is
Y
not allowed.
is not allowed. It is as simple as this.
Yes, yes.
Go through this.
I have just received a copy via WhatsApp. But as I find, I'll take instructions and come back, or let me take instructions and come back, before advancing any argument. What I find, prima facie, it is neither here nor there. It has been a very craftily drafted document.
Yes, very true. But then, if by this
That is
the
not the
issue can be
That is not the
put
case,
at
They are
rest,
now prevaricating from their stand. They are referring to this
Then
letter.
I'll argue all the points. Then there's
They
no
are,
difference.
they are referring to this particular letter dated 12th of March 2025. Now, what they are adopting, it is nothing but a moonshine. And second, is, now, this particular sanctimony, attempted sanctimony, that 3rd of May 2021, there was no bulletin. That is why.
well, that is over. Whatever happened on 3rd of May, 4th of May, 5th of May is all gone. Now, this is the stand of the speaker communicated through the secretary
It is
that it is it will
very
be made
unfortunate,
applicable
that the stand
for all.
taken is, nothing but beating around the bush. But I'll seek instructions, still, this is just a document that I have just received.
Very well. Yes.
May I
Please
come
come.
back on,
All right.
But only one request to my learned friend: this letter should not be shared because this is addressed to me.
I'll ensure that.
Please ensure
I'll
that.
ensure this.
No, korish na.
No, still do not go about.
It will only embarrass
No,
me.
I'll not.
The communication made by the Secretary West Bengal Legislative Assembly dated 22nd July 2025, addressed to the Learned Advocate General of the state, has been placed before this court. Stop. A soft copy of the same has been forwarded to the Learned Advocate, Learned Senior Counsel representing the petitioner. Stop. Next. As the matter is sub judice before the court, the aforesaid communication ought not to be sent out to the public at large. Stop. The Learned Senior Counsel seeks time to revert with instructions. Stop. After the puja vacation.
No, my lord was hearing this matter.
Yes.
This can be.
No session will be held in the meantime.
Kindly, my lord.
There are various other important issues.
Really important.
All issues are important, my lord. The Learned Advocate General, my lord, cannot pick and choose and say that there are various other important issues.
But
This matter, my lord, was already being heard.
Court
This
also
matter,
appreciates that there are
this matter was already being heard. These issues are also important. Had this
Yes,
honorable
when?
speaker been impartial. Now, my lord, here it is also seen, my lord, from the communication, my lord, as regards what regard he has for impartiality. But kindly takes it up on Tuesday, my lord. I'll come back with instructions, my lord.
Tuesday.
It's, my lord, instructions, my lord, quay this particular document.
Yes, the particular
Why
document.
do you need to attack the speaker for your client?
No, I'm not attacking anyone. I'm
That's what you have said. That's what you have said.
Just making my submission.
22nd, 27th of August, 2 weeks.
Great.
I'm grateful. But the letter may be kept on record.
Yes.
Well, could it be on 26th or 28th, Mr. Bandyopadhyay?
At the 26th.
I'm grateful.
Great.
Item 9, my lord, I appear on behalf of the petitioner, my lord. I am led by Mr. Thakkar. He is appearing virtually.
Kindly permit, Your Lordship had heard us on the last occasion. The Learned Advocate General was to make his submission.
But I would be seeking an accommodation, but I'm not prepared in this matter.
But in this matter also, the no ground has been taken in the affidavit in opposition, that the scheme has been withdrawn. So, my lord, I hope the learned Advocate General will not take that ground now to disentitle me from monies which I've already incentive which has already accrued.
The act that has been framed
Yes,
for withdrawal of the incentives
yes, my lord.
is a very draconian type of act.
Yes, my lord.
Go through it. Have you? I do not know whether you've
Yes,
gone through
no,
it
my
or
lord, I
not.
went through it, but I was, I was just hopeful that they would not take this ground because the opposition does not take this ground. Opposition is only on merits, and the act was already, my lord, in their knowledge. The bill was there. It is after the bill they filed the opposition. So I don't think they are setting up that as a defense in this case, at least. So I will not have to trouble your lordship with the wires of that.
I do not know.
Yes, but I'll consider.
Sir,
I'll
the
address
learned
your-
AG is very
Whether
fair,
it
my lord. I don't think
is
he will
not
argue.
there in the opposition. Whether you will rely on that or not,
Right.
please go through it.
But I think when the opposition was filed on 15th of January 2025.
My lord, subject to leave of the learned AG, my lord, it was affirmed on 21st of March 2025, my lord.
একটা কি তার আগে এসছে?
No,
The
it's
bill was there. The act was promulgated in June. The bill was already there. Bill was of
17th of March, my lord.
yes. Go through the dates, check up what will be the effect.
One has filed it on 21st of March.
One is the state, my lord.
State. Let me see, but I'll take my lord.
When?
Sometimes next week.
any date, my lord, your lordship gives, my lord. Any date.
On the prayer of the learned AG, hearing of this matter stands adjourned till 20th.
Kindly keep this also on 26, one after the other.
26?
Yes.
All
PPS
right,
and
26.
Not with those matters, my lord. Mine is a very simple problem. I don't want to get lost in that virus problem, my lord.
No. Virus problem is after the vacation I have posted.
Oh, very good. I'm sorry.
That is after vacation.
Right, grateful.
I'm grateful.
The learned AG has a number of matters.
Yes,
It's
my lord.
not
The
only
state,
one matter over
well, the
here.
state keeps him very busy, my lord.
Yes, he has to be.
So I've taken this burden on me. What can I do?
Certainly.
Grateful, my lord. Deeply obliged.
All right.
On the state respondent, my lord.
You for the state?
No, my lord. Without giving any notice that matter is coming.
কেউ আসেনি আমাদের লোকজন? For non-prosecution. All right.
Yes.
Your name will be recorded. Give your name.
Lord.
It is dismissed for non-prosecution. Call the next one.
In whether I am for Union of India respondent.
Yes.
I am for the petitioner.
Are you interested to proceed? Then it is being adjourned day after
For
day.
fortnight, I had been suffering from viral fever that causes me to appear, my lord, in virtual mode. Your lordship can recall.
All right. Anyway, now already you are all right. Yes.
Lord, we initially approached this court
because my lord, a contract was there for 5 years, a rail coach restaurant that is to be my lord, constructed by us and that is to be run. There was a clause that is to be initiated from 23rd of November 2024. 90 days was the period.
No, see, right now the joint inspection has been conducted
But
and
they-
thereafter a report has been prepared and
Yes,
circulated.
yes. My lord, kindly allow me to place it from the beginning, my lord, because something is there.
No, in the to be mentioned stage, it cannot be heard. I just wanted to inquire whether you are inclined to that.
Who are interested, my lord?
You are interested. The subdivisional officer has
But
said that there is
they
no
are-
nuisance.
they are-
Are you interested to continue in that position only?
We have to.
You have to.
We have
Now the contract is possibly the period within which it has to
No.
be accepted as
When I approached before lordship, they have cancelled the contract.
Yes. How long will they wait?
No, mal, kindly allow me to show 2 documents. What they are doing. Kindly have a look to my. Kindly come to my read petition.
No, but right now you say you are agreeable to
Run that.
run the restaurant. Whether the authority will be agreeable or not, I do not know.
My lord, they have raises new excuses, my lord, one by one. There is illegal occupancy. There is.
Kindly have a look to
My
page
lord, this is
25.
not the
what
part of
their
this
conduct,
case, my lord.
Kindly have a look page 25. That is not my letter. That is the letter by the my lord senior divisional commercial manager on 4th of September 2024.
No, it's long gone. See, this
Have a
is
look, my lord.
long.
Then thereafter the reminder. They sat tight over the issue.
Whatever.
They sat tight. The once I approach this court, they have come with a plea that they have already cancelled my candidature. How
Yes.
could they?
Has any new person been selected?
No, my lord. No, my lord. But they have, my lord, there is a letter in Hindi.
Which where is it?
My lord,
Page.
my lord, page 3, my lord. That report, my lord, page 3. Page 3, my lord.
Yes.
My lord, I am go through partly, my lord. My lord, शालीमार स्टेशन की सविनय निवेदन है शालीमार given by them, my lord. शालीमार स्टेशन से कुछ ट्रेनों की परिचालन शालीमार स्टेशन की जगह हावड़ा स्टेशन में शिफ्ट कर दिया गया है, जिसके ट्रेन संख्या शालीमार चेन्नई करमंडल एक्सप्रेस एवं शालीमार पूरी धौली एक्सप्रेस को अगले आदेश तक हावड़ा स्टेशन से परिचालन किया गया है. मतलब only 2 trains. Next, my lord. My lord, अवैध
No, whatever. What is the main gist of this? That they are
but
not
actually
interested.
they are new excuses, my lord.
They have applied
What
their
is
difficulties.
shifted, my lord? What is shifted? The train number. What is shifted? The spot was it? That is the not matter of this case, my lord. In addition to this, अवैध दुकान रेलवे प्रेमिसेस में चल रहा है, इसके पहले खाली कराया जाए और उसके खाली कराकर बंदर वाले कराया जाए. मतलब that is new excuse. मतलब if there is illegal occupancy, that is another matter. That is not part of this case, my lord. They are
May not be a part of this case, but if the place is occupied by illegal
no, no,
occupants,
that-
then
that-
how can the petitioner run the business?
well, not that.
We
that
have set up the
well,
railway
that-
track to
well,
bring
that
that particular
particular-
condemned coach. They failed to hand it over. They're
not
coming
that
to lordship with this
particular
document.
spot is that particular spot is occupied, my lord. In addition to this,
No, whatever.
public
Well,
toilet, well,
listen.
public toilet. That is not public toilet. That is a
Yes,
deluxe
the
toilet, my lord.
public toilet is under
Well,
consideration.
there is railway protection force, my lord. In addition to this,
Inquire as to whether the contract can be issued in favor of the petitioner, because the petitioner is agreeable to
no, that is
proceed.
expired, my lord. Their tenure is that is expired.
Show me the cancellation ones.
That was stated by your lordship.
Where is it?
No, that was my lord, supplied to your lordship dated 14th of May 2025. Not a part of this writ petition, but that was supplied by them in course of hearing. And I got it from this courtroom.
14th May 2025.
2025.
As per extract provision, contracts awarded if the contractor fails to pay the full. Oh, you did not pay the amount.
No, we have paid it.
with penalty of
The initial amount we paid, I have that.
thereafter, the balance is to be paid.
My lord, once the rail coach is handed over to us, once we build it up, then the next payment question come.
Due date of payment it was
That is the contract.
15th of February 25, but the same has not been paid within the extended period.
23rd
Contract is
November
terminated.
2024, by which the
And the EMD has been forfeited.
how could that be, my lord? But let me show two documents before lordship. What they are doing before lordship?
In that case, you have to challenge the termination all
Your
over
lordship was
again.
pleased to stay this.
Maybe.
Now, my lord, kindly, my lord.
For setting aside, I have
Two
stated for
things,
the
two
time
things.
being.
What they are doing. 4th September, there's a direction by the senior divisional manager. Please supply the rail coach. They didn't do so. Then the reminder by the self-same authority once again, and that is, my lord, at page. Page, kindly have a look. Page 28. On 3rd of October 2024, the same thing.
My lord,
They were reluctant.
My lord, in
Now,
previous
once they approach this court, my lord, they are coming with that plea.
My lord, in previous report, we have said
Had they, my lord, handed
we have
over
said
to us,
that,
my
my
lord,
lord, they have not given the proper cost, my lord, for tracking, for rail tracking.
That we have already set it up.
No, my lord.
That's my plea. You didn't provide me the rail.
They have not given proper, my lord, proper fees, my lord. They have not given
Fees
proper
for what?
For railway tracking, my lord.
This is something else. This is something else. We have paid as we were bound to pay in terms of the contract.
But that was, well, in
And
now even
they were bound to supply it by 23rd of April, 3rd of November.
Please come. Learned advocate for the petitioner submits that the petitioner is agreeable to proceed with the contract for setting up of the
Railway coach restaurant.
Railway coach restaurant stuff. It appears that the senior divisional commercial manager, Southeastern Railway Kharagpur, by a communication dated 14th May 2025, had already terminated the contract with effect from 23rd February 25, and the license fee and the earnest money deposit paid by the petitioner has been forfeited as per the policy. Paragraph. The writ petition is being considered by the court since 2024. Stop. During the pendency of the writ petition, the order of termination has been passed. Stop. Paragraph. The petitioner raised serious issues with regard to the position of the rail coach restaurant. Stop. Spot inspection was directed to be conducted. Stop. The same was conducted in June 2025. Stop. Presently, the petitioner, June and July. Presently, the petitioner submits that she doesn't have any other alternative but to proceed to set up the rail coach restaurant at the place that has been fixed by the authority. Fixed na kore selected by the authority. ঠিক আছে? Paragraph. The
16th of May, your lordship was pleased to pass an order making this particular rejection as abide by. That is well kept in abeyance by that order. The order dated 16th of May, paragraph 8 of that order.
Sixteenth of May, paragraph
8.
All right. The order of termination Now, paragraph di likhun je learned advocate representing the railways submits upon instruction that fresh tender is yet to be floated in respect of the rail coach restaurant. Stop. Under such circumstances, the court thinks it expedient to set aside the order of termination and forfeiture of the honest money deposit. Stop. The honest money deposit আর একটা হচ্ছে license fee. ঠিক আছে? The railway authority is directed to how soon can you pay the balance amount?
But balance amount, they have to indicate because it's a 1 crore for 5 years. Phase wise,
the railway administration is directed to communicate the petitioner the formalities to be complied for proceeding with the contract within 22nd. Stop. Release the matter on 27th August.
Great, much obliged.
The formalities shall be placed before this court on the adjourned date.
Great,
Your Lordship, I appear for the respondent in this matter. If this matter can be taken next week, Your Lordship.
For the respondent, which respondent? Which respondent?
All the respondents, the Union of India, all the respondents.
There are state respondents also. Will you represent the state also? Then all the respondent means which respondent?
One.
You do not have a copy of the writ
Your
petition?
Lordship, I'm not engaged in this matter. I'm led by Priyanka Tibrewal. There is some personal difficulty, Your Lordship.
So you are not there in the matter?
No, Your Lordship.
So you are holding brief of somebody else?
Yes.
Who is representing the Union of India?
Yes, Your Lordship.
So it's only respondent number 1. Others are all. Respondent number 2 is the state. Respondent number 3 is the Ministry of Home Affairs. FRRO. Indian Commissioner. Yes.
Kindly sees the last order. My urgency is that.
Yes, the children are there or the children are here. Something like this.
Yes,
minor son of the petitioner, reason for refusing. Yes.
If it can be taken next week, Your Lordship.
No, see, somebody is not here in court. The matter cannot be adjourned for so many days. The petitioner is in trouble. A minor son of the petitioner is not getting the passport.
Your Lordship.
Somebody should have been here.
The junior father died. Next week, Your Lordship.
On the prayer made on behalf of the learned advocate representing the Union of India. Release the matter on 18th, Monday.
On the same day.
Urgent motion, yes.
Grateful.
Urgent motion, my lord.
Urgent motion.
Good.
I am appearing on behalf of the petitioner.
Yes.
The respondent. My affidavit service, Lordship.
What is the matter?
In this matter, petitioner take loan from the PNB for house building loan. And after taking loan, he pay some near about 3,50,000. And thereafter, due to some financial crisis, he do not repay his payment. For that reason, his account is in NPA. Thereafter, a demand notice was issued by the authority, and thereafter on 7th, auction notice was also issued by the authority. Petitioner challenged the said.
Right now, a sale certificate has been issued.
The problem is this.
They have challenged the DM order, Your Lordship, and that they have also challenged before the DRT.
My lord, the DRT has held that the DM order has been, the DRT did not, my lord, interfere with the DM order and has given liberty to the bank, my lord, to approach the DM because there was a time limit of 6 months
For
in order
extension
for
of
extension of time. Bank has preferred such application, your lordship.
Lordship, in
My
the
lord, this
meantime-
petition
in the
is,
meantime,
and the essay is also pending.
the DM notice is for 6 months. This was expired, but on 4th August they come with a huge police person and come and indicate
Show
my
me the DM's order.
kindly come to page 36
36, your lordship.
and 37 is the lordship
6 months from September. It
September.
expired in March.
expiry and the order
Right.
of learned tribunal is next page, page 38 and it start when next page is
July
State
25.
Bank is to take no step was taken.
My lord, step has been taken, your lordship. Lordship, bank has
Fair
preferred
man
an
has
application
application
before the DM. My lord,
application.
liberty has been given. Page
Right, they will
39.
take steps.
Yes, your lordship.
No
What
step
remains?
is taken.
Yes, your lordship, step has been taken. We have.
All right, the bank will take steps.
Lordship, I am challenging this order.
Which
Lordship,
order?
DM order.
My lord,
DM
that-
order is
I'm
no longer in
challenging
force.
the learned tribunal order.
Tribunal order, you have to go before the appellate forum. How can you challenge the order of the tribunal over here?
Lordship, they come and they possession my physical possession of my property.
Please come.
Lordship, I am ready to, Lordship, one
The
thing, Lordship,
petitioner-
kindly give me, I am ready to
The
pay.
your ready to pay will not be accepted, madam.
Right to redemption has
There
gone.
is already a sale certificate issued.
Yes.
How can you pay?
Lordship, there is no DM order is no. There is no
DM order
order.
comes later on.
Expired, Lordship. It was
DM order
expired.
comes later on. The matter arises out of a SARFAESI proceeding.
এটা দেখালাম না
Stop.
কারণ কি
The petitioner as borrower failed to liquidate the loan amount for which
And I am
the
challenging
bank
the sale order also.
took steps
my lord, without
under
acting
the
the auction purchase as a party.
SARFAESI Act. Stop. An order under section 14 of the SARFAESI Act was obtained by the bank from the district magistrate, not 24 Parganas, on 18th September 2024, valid for a period of 6 months from the date of receipt of the order. Stop. Paragraph. Learned advocate for the petitioner submits that after expiry of the validity period of the order under section 14, the bank took steps for taking possession of the secured asset. Stop. The petitioner approached the debts recovery tribunal by filing SA 470/2024. Stop. Video order dated 16 July 2025. The tribunal directed the bank to take appropriate steps for extension of the validity of the order of the district magistrate. Stop. The securitization application has been made returnable on 11th September 2025. Stop. It appears that a sale certificate has also been issued by the bank in favor of the successful auction purchaser. Stop. The petitioner is aggrieved by the order passed by the tribunal. Stop. The order passed by the tribunal is appealable before the debts recovery appellate tribunal. Stop. It will be open for the petitioner to approach the appellate forum in accordance with law if so advised.
Lordship, only one thing, kindly, until and unless I am filing, do not take any steps.
They cannot take steps because they are yet to obtain order under section 14.
Only one line add. Only not to kindly add only one line. In the meantime, no steps are taken.
The bank may take steps to proceed in the matter only after the order under section, only after the validity period of the order under section 14 is extended by the district magistrate.
Grateful to your lordship.
Dada.
Milord, I am appearing for the petitioner in this matter, Lordship.
The respondent, Milord, I'm being led by Ms. Madhuri Devan, senior advocate. She's appearing, Milord, online.
Milord, in this matter.
Your Lordship, please permit me to appear
Yes.
online.
Milords, this is a matter where, Milords, I've challenged the order passed by the Director General of Competition Commission of India for multiple reasons, Milord. The first, the primary ground is that the Competition Commission in its order, the DG itself, the same body in its order of 20th February 2024, permits me to do cross-examination of all 19 witnesses. After that, Milords, on 1st July 2025, I'll bring Lordship to that order directly. Page 306, Lordship will have in volume 3, page 306.
Yes.
1st July 2025 order. 4 witnesses, cross-examination is pending. Milords, my right to cross-examination is closed. 2 of those witnesses were in prison on the dates that are mentioned. 2 of those witnesses, they have made statement against me and which is extracted in the DG report. I can show you all of that, Milords. I am not permitted to cross-examination. Of course, it is contrary to basic rules of natural justice. Otherwise, also, it's contrary to the CCI's own order. Milords, may just have page 306. It starts, Milords. 1st July 2025. Lordship has the order.
Yes.
Milords, if I may just take you through it. Commission vide its order dated 20th March 2024 had inter alia in view of the reasons furnished in its application and in terms of sub-regulation 5 of regulation 41 of the CCI General Regulations 2009 allowed cross-examination of 3 individuals. Further, in the interest of justice, the commission also directed that the opposite parties, I am OP1, Milords, to whom the investigation report forwarded be supplied with the oral statement recorded by the DG, giving them an opportunity to seek cross-examination of any such witnesses if so desired. The DG was required to conduct cross-examination proceedings in accordance with the observations of the commission and submit supplementary investigation report within 8 weeks of the receipt of the said order. Paragraph 3, Lordship. After seeking extensions, DG submitted supplementary investigation report on 3rd February 2025. The Commission considered supplementary investigation report in the ordinary meeting on 12th March 2025. Lordship, may directly come to para 7, which speaks about my application, OP1. I am OP1. Now, OP1 has filed an application dated 2nd June 2025, in which it has stated that it was permitted to cross-examine 19 witnesses, out of which it has completed cross-examination of 15 witnesses. Cross-examination of 4 witnesses, namely so-and-so, 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 remains pending. It is stated in the application by OP1 that the supplementary investigation report being prepared without awaiting completion of cross-examination of the OPs vitiates the process and is contrary to the order dated 20th March 2024 passed by the Commission. It is further stated that OP1 cannot file its objection to the investigation report and supplementary investigation report without being permitted to conclude cross-examination of all witnesses who have made statements in relation to OP1, especially since the investigation report and the supplementary investigation report rely on them. OP1 has suffered grave prejudice, so-and-so, so-and-so. Malaz, I am denied the right of cross-examination in this order, and I am asked to file my objections within 6 weeks. My difficulty is, Malaz, this is against the basic premise of natural justice, Competition Act section 36. Malaz, the act itself says that any action by the DG must be in accordance with the principles of natural justice. I don't even need to rely on any other law. The act, the statute itself provides for it. First point. Second point, my lords, that they have, and lordship, of course, there are judgments, my lords, which I'm carrying, my lords, to demonstrate to lordship that the denial of cross-examination is basically my right. It vitiates trial, my lords. My right to fair trial is taken away. I can show you directly from the statement, my lords, that there has been a clear breach of other witnesses who I want to cross-examine. Their statements have been put to my witness and questions have been asked. My lords, may please straight away, lordship may please have lordship page number, I'm sorry, my lords, this is annexure page 313. Lordship may just have annex page 313, volume 2.
But tell me, why are the 4 witnesses cannot be
No,
cross-examined.
now I agreed, Lordship. The 2 of those witnesses had been arrested. And Malaj, I have always agreed to cross-examine. 15 I have, of course, I could have finished other 4 also. But the point is, those witnesses were not available for some reason or the other. That is not my lookout. The point is, if you are relying either the CCI makes a statement that their statements will not be relied upon against me. If they are relying upon it, then I definitely need to cross-examine. One of those witnesses, Lordship, was enlarged on bail on January 2025 by Patna High Court. So, Malas, how do I cross-examine a witness who's in prison? My only request when I filed the application on 2nd June was that permit me 4 weeks. I will complete cross-examination, produce the witnesses I am willing to cross-examine. I have never run away from cross-examining. What is the urgency? What is the, because anyway, Lordship, the initial report, the first DG report came in 2023 and the cross-examination was to be completed within 8 weeks of May 2023, right? CCI, my lords, in any case took several extensions and filed the supplementary DG report almost 2 years later in February 2025, which was not given to me in February 2025. I have received it only in May 2025. Upon receiving it, I have asked for permission to cross-examine the remaining 4 witnesses. There was no correspondence from CCI to me, from the DG to me in 2025 at all. The last correspondence which they did with me asked.
Right now, your prayer is only for cross-examination of the 4 witnesses.
Yes, Malad, my only
Out
prayer
of
is
4, 2 have been released.
They are all
on
out.
bail.
Yes, they are
all
out. All are out.
All are out.
All are out. Permit me 4 weeks.
Where are they from?
They are from the witnesses, Lordship, are from I think 1 is from Kolkata and 3 are from Dhanbad.
And where is the cross-examination taking
Malad,
place?
it's conducted on VC virtually.
All right.
Malad, it's conducted by the DG's office, which is based out of Delhi.
All right.
I conducted virtually. So wherever the witnesses are, it doesn't. All the cross-examination, Malad, so far of 15 witnesses also have happened on VC. My only request is, Malad, that permit me, don't act on this supplementary DG report and the DG report without permitting me the right to fair trial. I'm not taking away. Malad, now second point, if I may show one more issue to Lordship. Malad, a blatant violation of the principles of section 145 of the Evidence Act. Malad, the Evidence Act, the very basic principle is that if you want to contradict my witness, you can contradict my witness on his own statement, not on the statement by some other witness. Malad, I can show you a judgment to that effect straight away. Lordship may actually first come to the statement itself. Malad, I'm showing you it begins on page, the statement of the witness begins on page, actually, Malad, it's there in my petition. Lordship may just come to my petition. Lordship may have paragraph 14, page 14, para 14 of my petition. It's all extracted also there.
Yes.
Malad, this is, Lordship, I've relied on a judgment of the Supreme Court. Chaudhary Ramji Bhai Narsingh Bhai versus State of Gujarat. Page 15, Malad, I've extracted. May I read that part, Lordship?
No, you tell me the facts.
Malad,
first
I'll
and
hand
then...
over the judgment also. I'm carrying a copy, Malad. I'll hand over the
judgment. That's all right, but tell me the facts so that I can
yes.
relate
Malad,
it with the judgment.
In this case, Lordship, what has happened is this is in the context of a criminal matter. But Malad, the basic principle of section 145 was that the witness cannot be contradicted using the statement of some other witness. He can be contradicted on his own 2 statements. And in that context, Lordship, in paragraph 11, Lordship may actually have the take to the win.
Yes.
Malad, Lordship, I have also extracted. Lordship may just see paragraph 11 of the judgment, what it says. Coming to the plea that contradictions by the trial court were ocular vis-a-vis medical evidence, we find on reading of the judgment it is not so.
Yes, yes.
Section 1, Lordship, para 11, I'm reading, Malad.
Continue.
Section 145 of the Evidence Act applies when the same person makes 2 contradictory statements. It is not permissible in law to draw adverse inference because of alleged contradictions between one prosecution witness vis-a-vis statement of other witness. It is not open to the court to completely demolish the evidence of one witness by referring to the evidence of other witnesses. Witness can only be contradicted in terms of 145 of the Evidence Act by his own previous statement and not with the statement of other witnesses. So and so, Lordship may then thereafter come down. I've extracted from the statement also, which is annexed. Page 16, paragraph 15 of my petition, Lordship may note. I have extracted the statement where they are showing my witness. Lordship may see that extract. Lordship may see, if I can just read the highlighted portion. You are being shown Exhibit 1, a portion of statement dated 23/6/2022 of Mr. Sanjay Khemka, where in response to question so-and-so, Sanjay Khemka said so-and-so, what do you have to say? So, second instance of that, page 17, my lords. In fact, the person whose statement is shown to me, this Mr. Gurpal Singh of GTS, he is one of the witnesses who I haven't yet cross-examined. And I wish to cross-examine him. He is the one who was imprisoned in Patna, in somewhere in Bihar. He has been enlarged on bail in January 2025. That's what my instructions are. He has been enlarged on bail. So, my lords, I'm willing to cross-examine. Give me 2 weeks' time, I'll cross-examine all 4 witnesses. Produce the witnesses. That's all produce in the sense, make them available. It's not and my lords, of course, the DG report is relying on these statements. So, Lordship, how can I be asked to proceed with the trial when the very fulcrum of it is contrary to established law? My lords, also, Lordship, there is another point that I
My lord, sorry.
My lord's attention to. Lordship, may please have my lord's paragraph 10 of my writ petition, page 7. My lords, there is the Competition Act. There is an office order passed pursuant to the Competition Act, and the office order is also enclosed, my lords. The office order, Lordship, will find on page 311. The basic point is this, my lords, that as per Competition Act's own office order, the CCI's own office order, Lordship, this is 311 volume 2. Yes. Malad, as per CCI's own office order, Lordship, they say that any investigation is to be headed by the DG or by the additional DG or by the joint DG, not by the deputy DG. In my case, my lords, this search, seizure, investigation, cross, everything has been conducted by the deputy DG. This is a very, very basic point of misuse of jurisdiction, Lordship. Well, let me see page 311, if I may just read paragraph 2, Lordship. However, as the investigation manual of DG 11, as the investigation manual of DG, 11 number of investigation units headed by joint or additional DG have been envisaged in the office of DG on the basis of sanction strength. Out of these 11 units, as on date, 10 investigation units are functional and headed by joint or additional DG. The unit consists of an additional or joint DG, deputy or assistant or OM and other office staff so-and-so. At present, the cases referred for investigation in this office by the Commission under Section 261, under 26 subclause 1 of Competition Act are assigned by the DG to the IOs individually by the name instead of investigating unit. As the investigation units have already been formed, the existing practice has been reviewed and it has been decided that in future cases for investigation shall be assigned to an investigation unit headed by joint or additional DG. Lordship, this is the office order dated 20th August 2015. In my case, my lords, the investigation started admittedly between May 2022 to July 2022 is when the investigation happened. So it's obviously much subsequent to the office order. So therefore, my lords, and my lords may just see the DG report, that will make it clear, Lordship. The DG report is in volume 1, my lords. Page 56. Lordship may please see, it's prepared by the Deputy Director General. Page 56, Lordship may have. This is the DG report. Yes. Lordship may see, bottom of the page, page 56, prepared by Priya Thomas, Deputy Director General, under the guidance of Dr. Atul Verma, IPS Director General, CCI. So, Malad, this is prepared by the investigation unit is headed by Priya Thomas, Deputy Director General. She is the one who has conducted the evidence investigation, all of that. And she is the one who has also signed on the DG report. So, Malad, this is prima facie, this is prima facie without jurisdiction. There are several ground, Malad, I've written, but I believe, Malad, for my only difficulty today is, Malad, I'm not trying to run away from it at all. All I'm saying is that my primary ground for coming to this honorable court? Because all these things, my lords, I was aware of earlier
Where
also.
did the cause of action arise here?
My lords, it's a subsequent cause of action. Lordship, I've come to this honorable court after the order of 1st July 2025, where my right to cross-examination has been closed. And a supplementary DG report relying on, Mala, that supplementary 306. Mala, that first order which I showed, Lordship, on page 306.
1st July.
Yes, 1st July. So, Mala, after that, I've been asked to participate in the trial without permitting, not participate in the trial. Basically, Mala, unlike in criminal matter, this is a trial. Objections will happen, final arguments will be heard, and the order will be passed against me. Now, Mala, but all I am saying is I'm not running away from any of this. Permit me to do the cross and don't act on this DG report or supplementary DG report without permitting me to do the cross. That's all.
All right. Yes.
But we are appealing for the all the respondents. I'm being led by Ms. Diwan. Network issue at her screen.
Yes, the learned counsel for the respondent, please.
I'm being told there's some question.
Network issue.
There are several other grounds also, Malaj. There is no, the basic satisfaction, the Competition Act under section 41 subsection.
Please pardon me, my lords, for the disconnection. There was a problem. May I address your lordships?
Yes, please.
My lords, first and foremost, my lords, I'll try and deal with my learned friend's arguments in sequence. First and foremost, she addressed my lord on the order dated 1st of July 2025 at page 306. This was an order passed by CCI. My lord, I appear for the Competition Commission. The DG is a separate wing, which I'll deal with later, my lords, when I mention I explain the overall scheme. But please note, this order dated 1st of July 25, which my learned friend read parts of, and which she says she is aggrieved by, is not the subject matter of challenge in this petition at all. We did not see any prayer or any ground insofar as this order is concerned in the writ petition with which we are served. May I just take your 51? 51, they were not aggrieved by this order, and I will explain why the cross-examination, because this is an attempt to, in our respectful submission, just delay the process, and that in itself can be a victory in competition matters. When you delay the process, the whole idea of checking competition, my lords, is defeated. So this is a usual strategy. Please see page 52, my lords. Prayer B does not mention any order, but prayer C, if your lordships sees, this is in challenge, my lords, to the DG report dated 31/7/2023 and the supplementary DG report dated 31/1/2025. Likewise, my lord, prayer D, they're dated 1st of July 2025. Now, my lords, what did we do by the order dated? That is an order actually passed by, my lords, the CCI, not the DG. What they have challenged over here before your lordships is only and only the DG's report, which is yet to be, my lords, we are yet to apply our mind on that. What we have done, my lords, because the procedure is this, and this is why I say, my lord, this petition is very, very premature, because, my lords, sorry. Yes, I'll just switch on, my lords, my video. I'm sorry. I'm not able to start my video, my lords, but if your lordships, yes, I'm sorry. My lords, the scheme under the Act is, under, my lords, section 26 has a very, very self-contained, my lords, scheme, under which, my lords, an investigation is first ordered by the CCI, and thereafter we've much past that stage. my lord, the DG prepares a report, and thereafter, my lords, the report, we can also order a supplementary report after giving them an opportunity, which is what we did over here, because they asked that we wanted to cross-examine. So we said, all right, you can cross-examine, you can proceed in the matter. Thereafter, my lords, I'll show the reasons why, my lord, they've already, out of the 19 witnesses which they wanted to cross-examine, they cross-examined, my lords, 15. And then your lordships will see from this order, which is not under challenge, as to how they dragged their feet very deliberately and why they did not, my lords, cross-examine. And eventually, my lords, we said that, all right, we are now, we can see that you are delaying the process unnecessarily. We are going to close the cross-examination, but you are given an opportunity to file your objections and suggestions, upon which, my lords, we will hear the matter on merits. Now, please see what my learned friend did not read from the order dated 1st July 2025 at page 306 is where it starts. But I'm going to just very quickly, my lords, mention that, may I just read what has happened over here, my lords? Just very quickly, and then I'll go to para 12 and 13, which are very important. My lords, please see. Para 1, the Commission vide its order dated 20th March 2024. My lords, this is 306. Had inter alia directed that in view of the reasons furnished in its application and in terms of sub-regulation 5 of Regulation 41 of the Competition Commission of India General Regulations 2009, be allowed to cross-examine 3 individuals of OP1. Further, in the interest of justice, Commission also directed that the opposite parties, OPs to whom the investigation report has been forwarded, be supplied with the oral statements recorded by the Director General, giving them an opportunity to seek cross-examination of any such witnesses if so desired. The DG was directed to conduct cross-examination proceedings in accordance with the observations of the Commission and complete the same and submit a supplementary investigation. This is what happens, and please see 3. After seeking extended report on 3/2/25, the Commission considered the supplementary investigation report in the ordinary meeting on 12/3/2025 and directed that an electronic copy of the non-confidential version of the supplementary investigation report be forwarded to the informant, the OPs, and their individuals identified by the DG for the purposes of Section 48 of the Act, to whom the investigation 23. Then, my lords, please see para 4. This is important because this first opportunity was given them to them to file objections. Now a second opportunity has been given. Para 4 reads, it was further directed that the parties may file their respective objections, suggestions to the investigation report and the supplementary investigation report, if any, within 8 weeks from the date of receipt of the order in electronic form, besides physical copy, along with a brief synopsis thereof, not exceeding so much. Now, my lords, please see what is my learned friend had read para 7, but 12 and 13, I think, were omitted. This is very important why we were compelled. And, my lords, this is an investigation which started in the year 2021 because of their dragging their feet and I'll explain why, my lords. In competition matters, time is of the essence. The more you wait, the more the party is able to defeat. And, my lords, I have all this, the cases of bid rigging. We haven't taken a final decision yet because we are yet to hear the matter. But eventually, my lords, if a party succeeds in dragging the matter beyond, and we are already 4 years down, then, my lords, the object is achieved in the process. Eventually, my lords, it is the consumer who suffers. Please see 12. Regarding the request on behalf of OP1 for cross-examination of remaining witnesses, the Commission observed that cross-examination of 5 witnesses has not been completed by OP instead of 4 witnesses as stated in its application. The Commission further decided that the said request of OP1 cannot be accepted in view of the fact that it was provided with ample opportunities to conduct the cross-examination of 5 witnesses, namely Shri Alok Kumar Agarwal, cross-examination scheduled on so-and-so, 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 my lords, please see these various dates. Shri Gurpal Singh, cross-examination scheduled on, my lords, these various several dates. Shri Manohar Lal Vishwakarma, my lords, several dates. All of these witnesses, my lords, please see. I need not read any more of this paragraph, but your lordships have noted several dates. Then please see 13. Despite being provided the opportunities outlined as above, OP1 has from time to time during the process of cross-examination expressed its unavailability and requested for rescheduling of the same. The Commission further noted that DG Vide email dated 26/11/2024 had communicated that if OP1 fails to cross-examine the witnesses as per the schedule provided therein, the cross-examination will be closed without giving further opportunity for the same. However, OP1 Vide email dated 9/12/2024 requested the DG to defer the cross-examination for 1 week and reschedule as per the dates it would provide by 13/12/2024. Yet till date, no email or communication has been received from OP1 in this regard. It is evident that OP1 does not intend to complete the cross-examination despite being provided with multiple opportunities by the DG. I wish this had been read in the opening to my lord. Therefore, the Commission decided that the process of cross-examination stands closed, and it directed that all the OPs and their suggestions to the investigation report and supplementary investigation report, if any, along with financials and other details as directed, we did the order dated 12/3/2025. Within 6 weeks from the date of receipt of this order, in view of the same IA's number so and so stand disposed of. Now, please note 2 things. One is, of course, my lords, that they have deliberately dragged their feet. So many dates were given to them. Neither did they cross-examine those last few witnesses, nor, my lords, did they file their objections as they were directed. Now, my lords, further we gave 8 weeks, but 8 weeks expired yesterday. They still, my lords, entails and what the further procedure entails, which is also very important. But, my lords, having read this order, I want to point out that my learned friend ought to have pointed out that she has not challenged this order at all. It's nowhere in the prayers. There are no grounds made out for this. And the arguments proceed as if this order is under challenge. It is not, and therefore you are deemed to have accepted what is stated against you in para 12 and 13. Now, my lords, coming to what is under challenge, which is the DG reports. Now, my lords, under the scheme, as I was pointing out, under 26 of the Competition Act, it's a very self-contained code. It has been, my lords, there's a landmark judgment called Sale of the Supreme Court, 2010 judgment, which explains this entire scheme and how the inquiry starts and where it ends. It starts, my lords, at the stage when the CCI, that is us, my lords, we direct the DG to conduct an investigation. That we have passed. Thereafter, DG submits its report. We may, if we feel when the report comes to us, as has happened in this case, because they requested and we then directed a supplementary investigation report. After that, my lords, we direct that, look, you may submit your objections and suggestions. Thereafter, we hear them, my lords, on the merits of the case, including all these points about who has been, my lords, the manner in which the witnesses have been confronted, or whatever they wish to say, they would be free to say before us. Eventually, my lord, one of 2 things may happen. We may even be convinced and persuaded by all of their arguments, and we may decide that we want to close the case. That provision is there under section 26 itself. I can show it to my lord. Or alternatively, after hearing them, we pass orders under 26(9) and 27, under which, my lord, there may be penalties also and whatever may have, but nothing without a hearing, my lords. That hearing has not taken place, and their objections to the DG report have not been received by us yet, despite twice opportunities being given. So your lordships can well imagine what the game is here. It is to drag the proceedings. It is not, because we are still, my lord, we are going to keep a very open mind on this, and we are going to decide, and they will have the opportunity, assuming, my lords, against them for a moment, that we decide no, that they are guilty of this bid rigging, which they have been, which is the charge against them. If they are guilty of bid rigging and we are persuaded to that effect, when we pass an order, they will have the opportunity to challenge it before the Honorable NCLAT. So there is, even at that stage, there is an alternative remedy. Today, my lords, what the writ remedy is unfortunately being used for is, my lords, to scuttle the inquiry, to somehow stall it. Because the law is, and this is again well settled in the sale judgment as well, is that the inquiry is yet not over till the final order is passed under 20. Either, my lords, it can be that we close the inquiry, that is also provided under 26 if we are convinced by what they say, or under 26, 27, we pass a penalty order or we pass certain prohibitory orders. In that case, my lords, that is the time the inquiry comes to an end. So this writ petition or this challenge itself is very premature, is what we are trying to say. My lords, I can show my lords that 26 and 27 for a moment. But before that, my lords, I'd just like to complete a couple of the points which my learned friend had raised. So, my lords, as far as the point about natural justice is concerned, I have already pointed out that, look, they got ample opportunities. This is an investigation of 2021 which started. You've had even a supplementary DG report. You've had, we also gave you an opportunity to be directed that cross-examination may take place eventually, because you did not avail of the opportunities. After multiple chances, we closed the cross-examination because we saw through what was happening over here. Second, my lords, insofar as this point about the additional DG, my lord, assuming for a moment, though I'll show that this is not a correct argument at all, assuming for a moment, my lords, that the additional DG, they have an objection to, that too will come before us. They can raise this objection. I don't know why they are shying away from filing their objection before us, because we'll consider it with an open mind. The issue, my lords, of the DG and additional DG, it's very simple, my lords. Under the Act, there is a definition, my lords, of a DG, and that includes the additional DG. So please see under 2G for a moment, Section 2G of the Competition Act.
No, but then here the issue is the deputy.
Too small, my lords. G said.
The additional one, not additional. Additional may be at
My lord,
par.
it is. I'm showing the addition. Yes, so I'm showing that definition, my lords. Please see, this is the definition of the Director General. Yes. Director General means the Director General appointed under subsection 1 of section 16 and includes any additional joint deputy or assistant directors general appointed under that section. So it is a very inclusive definition, point number 1. Point number 2, under section 16, your lordships will see everything is overseen by the DG. Please see section 16.
Tell me
Lord,
one
section
thing.
16 says.
Please tell me
Yes,
one
Lord.
thing. Is there a time limit specified in the Act itself within which the proceeding is to be concluded?
My lords, there is no specific. I'll just give under the, my lords, the sale judgment. What it says is, ultimately, my lords, time is of the essence, because there's a competition. There's a competition issue involved, my lord. You can wipe out the entire market in the meantime. So parties play. Eventually, orders may be passed again. My lord, typically, what happens is, even at the investigation stage, people challenge. They keep challenging at every stage. They do not allow you to complete what is a self-contained court, what is held by the Supreme Court to be a self-contained court, and so that, my lord, their purpose is achieved in the time being. So this, my lord, practice should be, and especially, my lord, when you have come here to challenge DG reports, which are still going to be heard, my lords. There's nothing is closed yet. This DG report by itself amounts to, my lords, it's not crystallized into a final inquiry order, because that is my prerogative as the CCI. So, my lords, therefore, I am saying that I must be given that opportunity. And if they wish to file their objections, they must do so, even though the second time given to them has gone by. If they wish to do so, they may do so immediately. We will hear them and we will pass an order. Now, and then, of course, they are open to challenge that order as the law permits them to. No difficulty with that. But, my lords, 16, I wish.
1 minute prior to moving further, the submission that has been made by the petitioner is that only 4 witnesses are left to be examined. One of the witnesses that has been disclosed was in prison and has been released sometimes in January. Now you've placed paragraph 12, which was not placed earlier, and I get to see that there were several dates provided for the cross-examination, which the petitioner possibly did not avail of, right? So what I was thinking, so as not to delay the matter any further, if a specified time limit is fixed within which the cross-examination may be conducted, and thereafter you can proceed. One, and second,
in my
you'll come back. And second, you've shown the definition of the DG, which includes the deputy DG also. So that submission, it goes.
That
and
sorry.
1 minute.
Very
And the issue that the entire process is without jurisdiction, that has, you say, has not been raised ever. Right. So that being the position, I was thinking, if a time can be fixed by the court within which the cross-examination is completed, and then you proceed with whatever the formalities and the procedure are in accordance with the act. What will you
that regarding that director, the deputy DG, well, that's 2 things. Lordship may look at page 311.
You have never raised this issue ever.
No.
Nowhere.
Well, there has been no scope. I'll tell you why.
Why no
scope? Please see, my lords. This
May
definition.
I respond, my lords?
Senior,
May I respond?
The definition that my learned senior.
I'm sorry. May I just respond?
Of section
Yes.
2G, that is referred to section 2G of the Competition Act, which says that Director General includes the Deputy Director General, is referred to in this office order, which is a subsequent office order passed by the same CCI. And despite that, they say that yes, the DG may have the same, the additional DG and Deputy DG may have the same powers as the DG for other functions, but for heading the investigation unit, it can be headed. That is what is written. Lordship,
no, but then it is being supervised by the DG. So it's no use.
But my lords, please see the office order. For a moment, my lords, may read the office order.
The office order.
I did not.
Just
one moment. I bow down. Second issue, my lords, regarding those dates that my learned senior is mentioning, Lordship may permit me, I will show you, Lordship, what the CCI does is, all 19 witnesses are listed for cross-examination on the same dates. So, my lord, this is their normal procedure. Lordship will see that for
Please
all.
wait. As regard the dates, I'll.
So, my lord, it is not correct to say.
1 minute. Yes.
My lords, as far as my lords, my learned friend's grievance in so far as the cross-examination is concerned, in my respectful submission, she cannot raise this in this petition because she's not simply challenged that order. It's as basic as that. So therefore, to expect your lordships, my lord, what they are effectively asking your lordships to do is to pass an order which is inherently without jurisdiction because there is no challenge. Not under challenge at all. And obviously, my lord, they thought this through because they have next the 1st July order. They've accepted the order. How can they, my lords, at this stage now? My learned friend has argued as though she is this is the subject matter of the. My lords, please see. My instruction that the DG is supervising everything, and let them file their objections as soon as possible. We will hear them, and we will hear them if they feel, if we feel at that stage that look, there is a problem, and they should have got any further opportunity. If we want to change our mind on this, my lords, we will do it at that stage. But my lords, today the message that goes out is that a party who has dragged its feet from, my lords, 2021. Then there is a public interest which is at play here. Neither the CCI nor the DG are acting for themselves. We're really acting, my lords. Ultimately, my lord, we are talking about extraction of coal.
I've followed it.
My lords, as regards dragging the feet from 2021, repeatedly the submission is being made, my lords. The permission to cross-examinations to commence cross-examination of 19 witnesses was issued only on 20th March 2024. And the right to close cross-examination was already done by November 2024. 19 witnesses. Malad, I cannot be held responsible if the witness is not present. Malad, I can show you from the order.
Show me that you've challenged from the prayers that you've challenged the 1st July 2025's order.
Malad, I bow down, Lordship. No, I have not challenged it. But Malad, my difficulty is, Malad, I have challenged the supplementary DG report, which is of 2025 in the context, and Malad, I have to challenge the supplementary DG report because my right to cross-examine, where they are relying on the statements made by the witnesses who I have not cross-examined, is part of the supplementary DG report, which I have challenged.
No, but then the learned counsel for the respondent is
I
correct.
have no difficulty. Malad,
Because 1st of July.
I bow down. Malad, may I make a simple submission then, Malad? Either Lordship may permit me to orally amend the prayer. Otherwise, Malad may permit me to withdraw with liberty. Tomorrow I'll file it, putting in that additional ground as a challenge as well.
I was thinking,
Malad, Lordship,
give you liberty to approach the Competition Commission of India with all your requests,
difficulty,
and they will take a decision. Because 1st July is admittedly not on the challenge.
Malad, all my submissions may be kept open. I'll approach the CC. I have no difficulty, Malad. That is what I had done. I have no difficulty, Lordship. Malad, all my contentions on the other points also may be kept open, Lordship.
Which other point?
Well, it's on the point of 145 Evidence Act, 140
Yes.
leading. There are several.
Who stopped you from making all these submissions? Nobody stopped you.
That's. I'm just.
So that is if they file their objections as they have been directed to do, which they are statutorily entitled to do, we will deal with all of it.
The matter relates to case numbers 48 of 2020 and 49 of 2020 under the Competition Act, 2002. Stuff. The petitioner claims to be aggrieved by an order dated 1st July 2025, passed by the Competition Commission of India. Stuff. After placing the arguments, it appears that there is no prayer in the writ petition challenging the validity of the said order dated 1st July 2025. Stop. Paragraph. Learned counsel for the petitioner submits that out of the 19 witnesses, 14 witnesses have been permitted to be examined, but the exact cross-examination of the balance witnesses have been closed. Stop. According to the petitioner, the delay in concluding the cross-examination was not attributable to the petitioner. Stop. One of the witnesses was in prison, for which cross-examination could not be conducted. Stop. Next. Further challenge is that the entire investigation is being conducted by the Deputy Director General. Stop. A reference has been made to the office order dated 20th August 2015, issued by the Director General, Office Director General, Competition Commission of India, which mentions about the investigation to be headed by the Joint or the Additional Director General. Stop. Jurisdiction of the investigating officer has been challenged. Stop. It appears that the issue of this jurisdictional error was never raised before the Competition Commission of India. Stop. Paragraph. Further issue is that the principle laid down in section 145 of the Evidence Act has not been followed. Stop. It appears that the said issue was also not raised before the commission. Stop. Paragraph. After hearing the parties in details, the learned senior counsel representing the Competition Commission of India submits that the sole purpose of the petitioner is to delay the proceeding. Stuff. It has been submitted that the commission will consider any grievance if the same is raised by the petitioner. Stuff. Paragraph. Upon hearing the parties in details, it appears that the petitioner has not made any specific challenge to the order closing the cross-examination of the witnesses who have not been examined. Stop. The petitioner has the other issues also as mentioned. Stop. It will be open for the petitioner to raise all issues before the Competition Commission of India. Stop. In the event such issues are raised, the commission shall take steps to consider the same in accordance with law. The writ petition stands disposed of.
My lords, the time for objection then may be extended, Lordship, because
you make a prayer because the submission, when you are coming to court, the time has already expired. Had you come within the time, then it could have been.
My lords, it's actually
Now it has to be done by the commission, and your prayer also has to be before the commission. So you make your prayer, let the commission decide.
I bow down, Lordship.
Obliged.
And take back this judgment because this has not been referred.
The affidavit of service.
Yes, it's taken on record.
AJT. Affidavit of service.
Obliged.
For the respondent bank.
Yes.
My lord, I'm for the petitioner, my lord. Here, my lord, at the instance of the petitioner's bank authority, an e-auction was processed under the instruction of the bank authority, my lord. And my lord, a notice was published for e-auction in the Times of India. And that is very vital, my lord. That is page 13, my lord. That is eligible, my lord. I'm giving another copy, my lord.
Page 30?
Page 13, 1-3, my lord.
1-3. Yes, Lagvana. Yes.
And it was the property which was for auction for scope, that is my HON'BLE food products, my lord. My lord, in
HON'BLE food products, yes.
That is for sale, my lord.
Yes.
And my lord, I have understand I have deposited, my lord. That is next page, madam. An agreement was done by with the bank authority, my lord. That is P14, P2, page 14, my lord.
Yes.
Thereafter, my lord, I have paid the earnest money. That is my lord, 49,000.
What is your prayer now?
My prayer, my lord, I have made the entire amount with the satisfaction within period, within stipulated time. But in spite of that, they have not registered or sold it in our giving possession to me, my lord.
Did you get the possession?
I am not taking getting possession or the registration.
Has the sale been confirmed?
Lordship, as a matter has been a very old matter.
no deed has been done.
2014 sale.
Yes, I can see.
Yes, thereafter, as per record, the Section 14 application has been filed.
Yes.
In 2015, Section 14 application has been filed, but thereafter, now the bank could not able to trace the order of the learned DM. That's why it's could not confirm whether the order has been passed or there is whether any problem. Position is not taken by the bank. Physical
Position not taken. You've taken the money.
Physical position is with the borrower as instructed by the bank. Verbal instruction. They submitted. I need some time, Lordship, because we need to approach the district magistrate office.
But then you have to check up your own records to see as to what happened to the.
They did not find anything. Only find the Section 14 application filed.
What were you doing from 2014?
Yes, Lordship.
The page 15 is the check, banker's check, 49,000. Thereafter, what about the balance?
Enter amount have paid.
Show me that.
That is my next my lord, page 14, 19. I have stated 77,000. Thereafter, I paid 3 lakhs. Entire amount. 5 lakh, total 5 lakh.
From 2014, you are waiting till 2024.
So everything has been changed. Allahabad has been merged. Indian Bank.
What is your client doing? Is he not
known
interested?
to anyone.
client has remitted representations and made demand of justice.
No, no, no.
Everything is there.
No, no,
Page 22, my lord.
Where is the representation?
Yes, my lord, that is page,
Your lordship,
that is page
2022.
22, my lord.
Then from 14 to 22, nothing happened.
Madam,
Come. How soon can you come up with instruction?
Please, your lordship, kindly give some time, your lordship.
How much? 2 weeks?
3 weeks, your lordship, because it be a very old
The
record.
matter relates to an auction notice published by the Allahabad Bank. Not auction notice, notice of sale. Published by the Allahabad Bank on 30th September 2014. Stop. The petitioner claims to be the successful auction purchaser and submits that the entire bid amount has been deposited, but the sale certificate is yet to be executed by the bank. Stop. The petitioner has also not been put in possession of the subject property. Stop. Paragraph. Learned advocate representing the bank seeks time to take instruction. Stop. Paragraph. In view of such prayer, hearing of the writ petition stands adjourned till 3rd September 2025. Stop. A report shall be placed before this court by the bank, disclosing all facts and figures.
Lordship.
An advance copy to be served upon the petitioner.
Lordship. Much of
Service is taken on record.
Did it? আমাকে দাওনি তুমি দিয়েছো।
My lord, I beg to appear on behalf of the petitioner in this matter.
Yes.
My lord, petitioner is a learned advocate and tax consultant who was considered by way of tender by the DI of schools AC for 4 subdivisions to complete the tax related works of the school teachers, like TDS, submission, deduction, various tax related works for the school teachers, because these are all statutory functions. It has to be done within time limit from 2018 to 2022. My lord, everything has been done by the petitioner with satisfaction. Kindly come to page 35. The satisfaction certificate has been given by the DI of schools AC, recording his involvement from 2019 to 2021.
Yes.
Even after that, my lord, even after the tenure, at the request of the concerned DI, he had continued for 6 months. In between, he prayed for his payment, that there is a due of 23 lakhs.
Where is the payment chart?
Yes, my lord. The prayer is at page number.
Not the prayer. Show me how much is the petitioner entitled to receive for the work that he is
That
doing.
I have requested the authority to release page 36. That no payment has yet
No, this is your request. How much is he entitled? Is there any rate chart fixed by the state government? Where is that?
Kindly see the tender notice itself. It is recorded there, page
Yes.
33. That is the last tender.
Page 33.
Page 33.
Yes.
I think it would be 27. Red chart is is given there. Red chart is
It is there in
page
the tender.
27.
I'm showing.
1.41.
1.41.
Yes.
Kindly come to page 33. My lord, kindly
R1 individual for submission of quarterly returns in the prescribed manner.
kindly come to page 33.
33.
That is the last tender. It has been enhanced to ₹7 at the last paragraph, page 33.
This is 21.
Page 33, my lord.
Yes, 33 is page 20. This is year 21 and page 27 is for the year
That is the last
20.
tender. That is the last tender. Kindly take the last paragraph. As per rate at ₹7 per one individual deducted. So it comes down to, for 2018 to 2022, it comes down to 23 lakhs 21,000 and odd. My lord, I paid that amount before the authority, the DI that kindly release that amount. I have not been paid a single farthing since 2018.
You started work from 2018.
2018. My first tender is
18-19.
18-19,
19-20.
2021, 21, 2022. These 4 financial years I have worked without a single farthing. Every time I requested, the authority said, whenever the government clears it, you'll be paid, which usually happens, my lord, that it will be cleared. Did not happen. Now what happened? After 6 months, I was continuing at first the request of the concerned DI, even after expiry of the tenure. Suddenly the password was changed and a third party was involved and the work was given to them. Very well, I don't mind because my tenure has been completed, but they ought to have come up with a tender in which I could have also participated. That was not done. Moreover, 23 lakhs, 21,000 and odd is still due. I have wrote.
Where is the work order? Page 32?
Page 33 is the last work order.
It's on yearly basis.
It is on one financial year. 18,
One
but it
financial
will be
year.
starting from page number 27.
2021.
27 is the first. Kindly take page 27.
27.
Page 27 is the first work order. Then, my lord,
2018-19.
page
All right.
30. Now, my
So
lord,
you want your payment?
payment I have already written to the Commissioner of School Education, being the highest authority. It is pending before the authority. That is at page 42. If my lord directs the authority or the DI to release the amount, my lord, I am entitled for it.
In the tender, or is there any dispute redressal mechanism? What is the mode of payment? How is it paid? After the entire year, or in
No, usually what happens
installments or
after-
phases?
after
quarter?
one financial year, the amount, whatever bill I raise, based upon that, the bill is released by the concerned DI.
Where is it mentioned?
No, it is
What
not-
is the stand? Let me hear. What is the stand of the
My lord, pays, my lord, this is the case. My lord, petitioner was allowed 1.41 paise per, my lord, per head, per individual. But for some documents which has not been annexed to the writ petition, some dispute arose. Petitioner was given to notice for, my lord, giving, my lord, the provide ID and password of different 4 subdivision. That has not been done. And not only that, petitioner.
Was it communicated to the petitioner?
Yes,
that is after
that was
2022.
communicated to petitioner.
All right.
Yes, my lord, petitioner submitted 2 bills with regard to, my lord, financial year, my lord, with regard to financial year 18-19 and 19-20. But thereafter, my lord, he was not continued. My lord, the documents has been, my lord, page 33. My lord, the rate chart that is alleged because district inspector of school itself cannot enhance that amount. It's a, my lord, centralized system, school education department, my lord, controlling. My lord, he has, my lord, charged 7 rupees. That is not at par. That is why the Commissioner of School Education, my lord, withheld, my lord, entire. And my lord, he has not complied with the, my lord, some objection raised by some teachers and non-teaching staffs that my lord, ID and, my lord, password has not been given, and, my lord, IT was not uploaded properly. That is why petitioner was given, my lord, 2 notices, my lord, for giving, my lord, providing, my lord, document that has not been given. It would be convenient, my lord, I feel, with the petitioner, it would be convenient if your lordship kindly relegate matter to the Commissioner of School Education, because the Commissioner of School Education and School Education Directorate is the authority.
Is there any representation before the commissioner?
Yes, page 42.
Page 40?
42. My lord, I agree to what my
There is-
learned friend
yes,
is submitting. My lord, that will be
There is
written.
some dispute, my lord,
Only one
after
thing-
giving opportunity to the petitioner and the district inspector school, my lord,
Only one
you
thing
will
before
take a
your
decision.
lordship passes the order, I clarify. The 7 rupees has been issued by the DI. It is not my.
I am alleging that
Now, the
documents.
second thing, the password is for the DI to change. It has already been changed.
The petitioner complains that despite successful completion of work,
They have given the satisfaction
payment
certificate.
has not been made to him. Stop. Paragraph, the petitioner was issued a work order for outsourcing of income tax deduction in respect of teaching and non-teaching staff of non-government aided recognized senior schools under the District Inspector of Schools within bracket secondary education Hooghly
May I take your lordship's leave, ma'am?
for the financial years 2018-19, 2019-20, 2021 and 2022. 21, 22. Stop. The petitioner made representation before the Commissioner of School Education which is pending consideration till date. Paragraph. Without going into the merit of the claim of the petitioner, as it appears that a work order was issued in his favor and a completion certificate has also been issued by the District Inspector of Schools Secondary Education Hooghly way back on 23rd August 2021. Accordingly, the instant writ petition is disposed of by directing the Commissioner of School Education to consider the prayer of the petitioner for releasing payment for the work done in accordance with the tender document after giving the petitioner reasonable opportunity of hearing.
Petitioner, including all
As the
interested.
petitioner and all other necessary parties, reasonable opportunity of hearing, and dispose of the prayer of the petitioner at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
My lord.
Step. The amount that may be found due and payable to the petitioner shall be disbursed without any further delay, subject to compliance of all necessary formalities.
My lord, admissible amount, my lord, may I pray?
Learned advocate for the petitioner is directed to forward a copy of the representation along with all documents in support of the claim to the aforesaid respondent at the time of communicating the order of the court. Yes, please.
Admission, my lord, instead of amount, my lord, it would be convenient admissible amount, because
The moment I write admissible, that means there will be a dispute.
dispute is there, that is why I am withheld. Great.
Next.
Affidavit of service. My lord, petitioner became the successful bidder in a retender process. That retender order was cancelled omnibussly without assigning any reason.
Omnibus?
Because I was a successful bidder, and in a retender. First the
Yes,
tender
yes.
was given, I was
Right.
kept the, thereafter again the retender was made because the non-participation of the members.
All right.
And thereafter the retender process, when the everything was done complete, technical bid, everything was complete. Thereafter, without assigning any reason, the tender was cancelled.
Hmm.
I have
Who's
challenged
the
that one.
authority
My lord, it is the medical superintendent.
of?
Shastro Bhavan. It is a medical college. Medical superintendent, vice principal, medical college and hospital.
Yes. Will you be representing the medical college
No, my lord, I am for the respondent number 2, my lord, the commission.
or the state commission?
Shall I give another notice?
Where is your notice of upgradation?
Notice, it was given notice. My lord, I have given the notice. It is in my chamber. I'm handing over. I'm handing it over.
I need to see it before I pass orders. Your paper will be in your chamber and you expect the court to pass order. I need to see who's appearing for the medical college, whether you've served notice or not.
I've served the notice to them. My lord, kindly do another thing. My lord,
Listen, there is a specific note in the list itself that the notice of
I have
upgradation
given the
has to be
notice. I'm
given.
very much candid. I'm giving the notice.
I am not disputing, disbelieving or anything, but then I want to see that the notice has been served.
My lord, kindly do one thing, my lord. Kindly fix it on the next week so that I can give another notice to them.
So it is not done in this way. There is
know
a
that.
manner as to how the list has to run.
I know that, my lord. It is in my chamber. It will take 10-15 minutes to bring.
This is a matter of 23.
23.
It has been upgraded and there is no notice of upgradation.
Madam-
Was any notice given to you?
No, it is given.
See, the learned counsel
My lord,
is
that
saying
notice
it is
with
not
us.
there.
My lord, I'm very much candid and notice it with us. Notice is with us.
The matter has been upgraded citing urgency. Stop. The notice of upgradation is not before the court. Stop. Release the matter for further consideration on 2nd of September.
Shall I give another notice?
It is your choice.
Hello.
Grateful, Lordship.
Lordship, in this matter, Advocate Swarupal is appearing. He has left the court because of some personal difficulty, Your Lordship. I am praying for not today, Your Lordship.
Upgraded matter, not today.
His personal, he was here, my lord.
I do not know. The court is permitting upgradations, and if adjournment is sought, then I do not know. What is the matter? Who are you representing? Who are you
I'm
representing?
representing the respondent number 1, madam. Webfield.
Webfield.
But I have a preliminary objection as to the maintainability of the petition.
Right. What is the objection?
My lord, this is regarding a tender matter, my lord, and the respondents, my lord, do not come within the meaning of state.
It's not Article 14 authority.
Yes, my lord, because my lord,
Article 12. It is not the Article 12 authority.
my lord, and moreover, my lord, regarding Andrew Yule, that is the other respondents, there is a
Yes.
judgment of the division bench stating that it's not coming under. And I am a, my lord, joint sector company between the West Bengal Industrial Development Corporation and group companies of Andrew Yule. So and is that is not that aspect has not been pleaded. And my lord, moreover, my lord, I am not discharging any function of the state regarding which this tender is being floated.
The matter has been upgraded, citing urgency. Stop. At the time of call, accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 2nd of September. Service in the meantime to the non-appearing respondents.
Lordship, did you appear on behalf?
May I please your lordship, Lord?
You appear on behalf of the? All right.
Lord, I am appearing for the petitioner, Lord. Lord, the unauthorized construction encroaching the PWD land, my lord, kindly straightway come to page number 34.
Yes.
Lord, the assistant engineer, before that, my lord, 33, the demarcation has been done and it is well settled and admitted that yes, encroachment has been done and PWD land by encroaching construction. The assistant engineer directed to remove the illegal construction, last fourth line, and restore the non-jewelry, etc. Whatever is, and in future, in the event your refusal or failure, legal recourse should be taken. But nothing has been done thereafter. That is the
Please
response
come.
number 2.
Yes. What is the submission? All right. Please come. The petitioner prays for implementation of the direction passed by the assistant engineer, PWD Kontai subdivision on 30th April 2021 for removal of the for stopping and removal of the illegal construction work and also to restore the Noyanjuli in the previous condition so that the waterway obstruction does not occur. Stop. Paragraph. Specific submission of the petitioner is that despite such direction, no steps have been taken. Stop. Paragraph. Learned advocate representing the state respondents is not ready with instruction. Stop. As it appears that the assistant engineer PWD has already come to a conclusion that there is illegal and unauthorized construction over public land. Accordingly, the assistant engineer ought to take steps to ensure that the order passed is acted upon and complied by the concerned parties. Stop. Next. The instant writ petition is disposed of by directing the respondent number 5 to take steps to implement the direction passed in the notice dated 30th April 2021 in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stuff. Paragraph, learned advocate for the petitioner is directed to forward a copy of the notice dated 30th April 21 and all other supporting documents to the aforesaid respondent at the time of communicating the order of the court.
Much obliged to Lord.
A very innocuous frame, lad.
Yes.
But if you stateway comes from 215 of the petition, lad. I have worked with that government lad, in advertising, lad. Now, lad, there is some 15.
15.
Some payment is due, lad. I have made representation to them. Lad, I have made representation to the Union Ministry also, lad. They have forwarded my representation to the concerned authority.
Show me the work order, please.
Lad, work order page, lad. 32 to 36, lad.
Telecast of government advertisements in Doordarshan, Kolkata.
I have done that. Now, lad, payment is due since long.
2011 work.
Now, lad, several correspondence has been made between the parties. This is the last correspondence, lad. That's why I have
Last correspondence is page
2022.
Page
215.
215. Petition from Binoy Bhattacharya on behalf of such and such. Dated the country.
First paragraph, last line. This application was forwarded to the Ministry of Home Affairs.
Government of India.
Yes. Well, last resort, I have made the representative to them. They have forwarded this letter to them, to this authority. This is the authority concerned, lad.
Who is to make the payment?
Lad, this 2 and 3, lad. Two and 3 is the lad concerned authority. To them only, lad, this was forwarded, lad. Let them take a decision.
You are reviving an old claim of 2011. Please come. The petitioner prays for releasing payment for the work performed by the petitioner in terms of the work order issued by the Government of West Bengal, Department of Information and Cultural Affairs.
(32 to 36).
A representation on behalf of the petitioner was page 260 is the mediation center.
No, this is the representation that they have forwarded. I missed to annex that 2022 letter refers to this of 2018. Rather, 2018.
This is to the Home Minister, Government of
That has
India.
been forwarded. Can you take some 215?
Sure, Baba. Where is your representation?
To the authority.
Yes.
To the authority, I have made representation at 213.
213.
213 along with the dues, indicating the dues that they have to make.
213. This one page is all right with you?
All right for me.
আচ্ছা ঠিক আছে.
A representation on behalf of the petitioner.
Not on behalf, a representation by the petitioner is pending consideration at the end of the Secretary, Information and Cultural Affairs Department since 2022. Stop. The details of the bill, the date and the amount due are mentioned therein. Stop. Next. Without going into the merit of the claim of the petitioner, comma, as it appears that the prayer is pending consideration before the authority. Accordingly, the instant writ petition is disposed of by directing the Secretary, Department of Information and Cultural Affairs to consider and dispose of the prayer of the petitioner in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The amount found due and payable shall be disbursed in favor of the petitioner without any further delay. Stop. It will be open for the respondent authority to give an opportunity to the petitioner to place documents in support of his claim if required.
Grateful.
Disposed. After finish, the learned advocate for the petitioner is directed to forward a copy of the representation to the aforesaid respondent at the time of communicating the order of the court. Representation along with all supporting documents.
Grateful.
Lordship, I'm led
My
by
lord,
Mr.
before my learned
Mukherjee.
friend start, I have a point of demerit with regard to the territorial jurisdiction.
With regard to the
Territorial jurisdiction.
territorial jurisdiction.
I also have the
Lordship-
same point, 54, kindly come. Yes.
Lordship, before my seniors place the matter, Lordship, Mr. Mukherjee is leading me in this matter. Kindly,
Which
Lordship.
Mr. Mukherjee? There
Mr.
are so many Mr. Mukherjees.
Mr. Mohit Mukherjee is leading me in this matter,
Yes.
Lordship. If your Lordship kindly keeps this matter at 2 p.m., Lordship, he's
2
on
p.m.
his
I have
next-
Okay, my lord. But you also kindly come to page 54. This court has no jurisdiction, I think.
Related to tender of Bokaro Steel. They belong to Bokaro. And
Are you the
work
advocate
order
of record?
Indeed, Lordship.
Then
work order of Visakhapatnam.
please, they are raising objection with regard to the territorial jurisdiction, page 54.
Kindly come.
Lordship, they're entering into the merits of the case, your Lordship.
Not merit, jurisdiction.
I would be
point.
prejudiced, your Lordship. I'm
Page
led by a senior
54.
in this matter.
Bokaro seals Bokaro Jharkhand, and the tender was issued from Bokaro.
And the cause of action arose in Bokaro itself.
Of course.
Nothing in West Bengal.
But I have not found anything.
No.
Nothing.
No.
Who are the parties over here?
What to be done at Visakhapatnam?
State of West Bengal through the Secretary Home and Hill Affairs Department.
We are not at all.
Union of India, Steel Authority of India, Bokaro
Secretary
Steel
has
Plant.
debarred from them for participating in the tender, but that tender
Tender
is
have
of
been banned. They have been banned.
Steel Authority
Alright.
has every officer.
You are for sale?
I am for the FSNL.
I
Feroz
You're
Camp.
for sale?
Yes.
Yes.
I have the same objection, my lord. Work order was issued from Bokaro, Jharkhand. Work was carried out at Bokaro, Jharkhand. Banning order was issued from Bokaro, Jharkhand. And even
In
the
So
respect
part of the cause
Visakhapatnam.
of action arose within the
In respect of
territorial.
Visakhapatnam.
as state
Lordship, they
has been made.
Lordship, they're raising this
The
issue. your
FSNL
Lordship.
also has not
Mr.
made a party.
I'm
They
led by a senior in this matter. Lordship, if your Lordship kindly keeps this matter at 2, otherwise, Lordship, I would be prejudiced.
Cannot be helped, madam. Difficulties. These are matters which are pending for long. It has been mentioned citing urgency, and at the time of call, you seek adjournment.
Lordship, he's on his legs in court number 32, your Lordship.
All right, I'm passing it over because this is going to continue. Let him come.
Much obliged.
Next.
Number 14, Malal, I am for the matter.
Yes.
It is affidavit of service, Malal.
Malad,
Yes.
if it matter, Malad, kindly consider what type of practice is going on. Malad, this has been served upon me today, saying that upon noticing you, this has been mentioned and matter has come up before Lordship on item number 14.
Malad, the
But it
matter
has
is
never,
of
no
Article 24.
notice was served upon
I
me.
have served several notice. This was mentioned earlier. Malad, this notice was served because it is appearing as urgent motion. Your Lordship instructed that a notice has to be served upon the other side.
Does it mean that today the matter will be taken up and you serve a notice upon him today?
Inadvertently not served, Malad. Today morning I saw it is not there. I served a notice, but it is mentioned. I do not know, my learned friend is.
Where is the notice of mentioning?
It was done, Malad.
Where is the notice of mentioning? Show, please.
Well, it was not.
Nothing.
Well, I'll say,
Then?
well, your lordship indicated that in your lordship's list monthly.
Had to, because in each and every matter, the same thing is to be repeated.
Sleep was made, it was subsequently probably has been misplaced. That is the.
There is nothing on record.
No, that
Your misplacing doesn't matter. It's your document. You go and misplace it. The court is not
I am
concerned.
not on that, I am just making an explanation to that. My issue is very short. May I just place it? There was
Issue is short. The petitioner, the respondent authority is not put on notice. The respondent doesn't know what the matter is about.
Twice I have served earlier notices, twice.
Show me the copy of the notices that you served, Mr. Shamanto. Show it to him.
Junior. This was mentioned on 3-4 occasions earlier. It's of 2024 matter. I have served notices. This is not the first time I'm serving him.
The last time it was mentioned, it was not served. But I am not.
And you are not a party, possibly.
Yes, yes.
It is the State Information Commission.
State has been made a party, madam.
The first appellate authority.
Service to the government of West Bengal. Respondent number 1 plus CIS service to the government of West Bengal. In other way, I am.
This is not how it is to be done. SPIO is the land acquisition officer. What do you want?
Well, nothing. I made
Nothing.
I made an RTI application.
Yes.
Response. First appeal, no response. Second appeal, no response. Thereafter, they sought for particular information in respect of the information sought.
Who sought for?
The SPIO. We served the information. They sat tight. We made a representation that we have served the information to you. Thereafter, no steps taken. Kindly comes to.
Show me the query.
Page 19, The reply is in page 20,
Show me your query, please.
My query is at page 12. There were 3 queries, in respect of DAG number 48, 63, 84, and 79.
You say DAG numbers under which the CS or the RS?
That was clarified. They sought for that information. Kindly comes to page 20. This was
CS plots.
This was clarified.
Whether CS DAG numbers at the measuring about that has been acquired by the state. If so, please supply documents. Whether compensation was paid. If the company, please. How are you related to these DAG numbers?
I am not related, but we want.
Why will you want information about somebody else's DAG numbers?
Because there is a dispute in regards to acquisition. That is the reason.
How are you related to this DAG?
I am not directly related to the DAG.
Why will this information be provided to you?
Take a decision in
Why?
respect of the application.
Why? Tell me, what is your legal right? What legal right of yours have been infringed? You have approached the 226 bench. You have to show infringement of a fundamental right. What is your fundamental right to obtain information of somebody XYZ's DAG numbers?
I am not asking for the DAG number of that particular. All I am asking for kindly comes to page 12, madam.
I am at page 12.
If the land was acquired, whether compensation has been paid to the owner. That is the reason, because.
Yes, but are you the owner? Then?
I am not the owner. I am a citizen of the country.
Citizen of the country has a lot of plots. Go and take information about many plots. Why particularly this plot? What is your intention?
Intention is to obtain the information.
Why? What will you do with the intention?
Understand what is the status of the land. That is nothing else.
Serial number 3 says it's a third party information. Serial number 3, where the information
under the act,
third party, yes.
Under the act,
no third party can be provided. Information can be provided.
They can well reject the application. Let them take a decision.
The petitioner intends to obtain certain information under the Right to Information Act 2005. Stop. The query has been placed in court. Stop. It appears therefrom that the petitioner intends to obtain information of certain plots with which the petitioner claims he is no way related to. Is it a he or a she? She is nowhere related to. Stop. Paragraph. It does not appear that any of the fundamental rights of the petitioner has been infringed by the act of the respondent, requiring interference by the writ court. Stop. In view of the above, the writ petition fails and is hereby dismissed. Service is taken on record. 115, there is a matter fixed. Please call.
Let it take place in camera.
Will be disclosed. Absolutely no disclosure of identity. Open it. Open it.
কন্ট্রাক্টর ওইটা আগের দিন যেটা জিজ্ঞাসা করেছিলেন সেটা দিতে হবে তো ওটাতে হ্যাঁ 4 তারিখের চলবে কিছুক্ষণ তো
No, this is the last matter before recess. So you all can leave.
Possible matter will be taken up now or after that?
I'll come back. I'll finish this and at 2 o'clock it will be taken up.
দুটোর পরে
As in.
Yeah. Oh,
The decision is against you.
I don't know.
I do not know anything. Knowing.
I understand. This is the reason I wanted in a seal cover. I'll give it to you.
Who made it?
Just hand it over to him. I have read only the last portion.
Malan.
Let Mr. Sen also see.
Malan.
So it will not be proper.
Without disclosing this to my client.
No, you disclose, you do not disclose. The experts have said this. The court cannot go beyond this. Isn't it? It will not be proper.
I'm also thinking in the same line, but she has to know first.
What will she do by knowing it?
It's my, I should inform her because it was her decision. So from my side, I should intimate her.
Very well.
Whatever is the decision.
Whatever is the decision, you intimate and it will be reflected in the order that this is.
Kindly keep it tomorrow so that I can have a discussion with her.
What will be the fate of the discussion?
Maybe nothing. Maybe nothing, but.
All right, please come. A report. Dekhi. Report filed by the MSVP IPGMER -SSKM Hospital, Kolkata, dated 12th August 2025, in a sealed cover, is placed before this court by the learned advocate representing the respondent authorities. Stop. The same is opened in open court in the presence of the learned counsels representing the petitioner and the respondents. Stop. the opinion of the medical board. See the number of doctors. 1, 2, 3, 4, 5, 6,
I've seen that.
7, 8, 9, 10, 11 doctors.
I've seen that.
কি বললাম?
The opinion of the medical board.
Consisting of 11 doctors. Is shown to the learned advocates representing both the parties. Stop. The unanimous recommendation of the board is not to terminate the pregnancy of the mother at this stage. Stop. Next. On the prayer of the learned advocate representing the petitioner, comma, the matter is posted for final disposal tomorrow.
And may I get the,
You want it?
yes, otherwise,
Very well. Let a copy of this report be prepared by the by the ACO of the court and handed over to the learned advocate representing the petitioner.
well,
Report
I'm-
will be
I'm
kept with the
deeply
records.
on the last occasion, my lord was asking me from that judgment, I could not show that Supreme Court has allowed ultimately medical termination.
Very well. Now I will not go into
In
anything
the
else.
previous occasion, Supreme Court has observed and in that
With
matter.
you now, this 11 doctors, there is no.
No, regarding this, I am not saying anything. It's beyond.
এটাকে একটা
tomorrow, 11, that's 115 or 1.
115. Very well, 115.
Tomorrow one. I'm deeply upset.
Just formal recording of a
Yes.
dismissal, disposal, nothing doing. জানাবাবু এটা কি করছে? Yes, call the list.
My lord, I appear for the petitioner, my lord.
Yes.
My lord, this is my writ petition against a wrongful withholding of my title deed by the ADSR Additional District Sub Registrar Guma since 2007 without disclosing any reason, my lord. My lord, I'll just briefly indicate the facts before I take my lord through the documents, my lord. My lord,
When was the document registered?
yes, my lord, it has registered. I have
When?
in 2007, I have been issued an IGR receipt,
Yes.
which is in page 17.
In 2007.
Yes, my lord.
Why
They
did
are-
you file the writ petition in 24 from 7 till 24?
But I indicate, my lord, I have been constantly following up. I had been told that there is a criminal case pending which concerns this deed, my lord. Now, my lord, there is no criminal case pending against me or my buyers. I subsequently come to know that a criminal proceeding or rather a departmental proceeding has been instituted against the ADSR of Guma, with whom I have no relation at all. My lord, due to this criminal proceeding, my deed has not yet released to me. Now, my lord, after I conduct inquiries, my lord, I came to know that on 3rd October 2013, this particular criminal proceeding has been dropped. I immediately issued them a demand justice telling them that, look, you told me that due to this proceeding, my deed could not be released. My demand justice of 12th July 2024 at page 24. I intimate them that this is the proceeding, but now I have come to know that this proceeding has been dropped.
Please wait. State.
Yes, madam.
What is the submission?
The thing is that the VIGR range 2 Barasat white memo number such and such stated that those disputes between the documents were delivered to the parties concerned. Further investigation in respect of the government revenue might hamper. He also mentioned that beside those documents, there might exist some other disputes documents in Guma registration office. Paragraph number 3 it is stated.
1 minute. Serious financial regulation collection revenue blind
Well, they had replied to my demand justice. My lord will kindly see their reply once.
Which document were you referring to?
Yes,
They
my
have replied.
My lord, my IGR, my lord, my demand justice is at page 24, my lord. I
The
specifically,
reply?
yes, my lord. The reply is in page 30.
Hmm.
The reply dated 16th July 2024. My lord, will note that do not refuse the fact that my deed is with them or that it is a specific police case against which the deed was being retained and that police case has been dropped. They say that there is a memo under which I required, the memo is on the immediate next page, my lord, 31. And a proper typed copy is at page 32.
Yes.
My lord, this memo states, if my lord, may please the
So
memo
this is
that
2007. This is all over. I want specific instruction from the IGR, right? As to what will be the further steps to be taken in this matter, since the criminal proceeding has been dropped. Followed. Where have you mentioned?
My lord, giving one paper, they are doing all these things, my lord. They are registered some some money paid, my lord, and all the registration will be done, my lord.
My lord, the IGR,
The huge revenue will be suffered, my lord. If government-
Yes. Tell me, where is the
IGR receipt, my lord, is at page 70.
1779.
The buyer's name in there and in the sorry, the buyer's name is there. It is the petitioner before, my lord.
Shanti Kumar Das?
No, my lord, that is the vendor. The buyer's name is Abu Shala Mondol, my lord. just
Yes,
below.
behind.
That is the petitioner.
At the
below.
back side,
This Malad is a proceeding against the ADSR Guma.
9-3.
I have no connection, Malad, with this proceeding.
Yes, you do have connection. Please come.
Malad, may I just say one thing, Malad? Malad, in similar manner, Malad, I have annexed 2 orders by 2
I have
coordinate
seen those
witnesses.
orders.
Same ADSR.
A property purchased by the petitioner was submitted for registration in the office of the sub-registrar Guma, not 24 Parganas. In September 2005, the IGR receipt number issued to the petitioner is 932098. The original deed has, however, not been returned. The petitioner submits that due to pendency of a criminal case against the district sub-registrar, the title deed was kept in custody. It has been submitted that the criminal case has been dropped or disposed.
Has been dropped. That is the word used in the order. Order is at page 22.
22.
The operative portion is in page 23. Malad is the last paragraph.
Has been dropped
Hereby dropped. Yes, sir.
by the learned judge, special court, 3rd court, Barasat, on
3rd October 2013. Malad.
3rd October 2013 in special case number 19/2007. The petitioner prays for return of the deed. Learned advocate representing the state respondents has obtained instruction from the Additional District Sub-Registrar Guma North 24 Parganas, signed on 12th August 2025. It appears therefrom that the Additional District Sub-Registrar had communicated to the IGR and CSR, West Bengal, to remove the restriction to deliver the 165 deeds of 2006, including the deed of the petitioner. A letter was also forwarded to the district registrar, but no order has been received by the ADSR for releasing the deeds. Paragraph. The court is of the observation that if the criminal case which was filed against the
ADSR Guma, Malad. One which is
against embezzlement of government revenue has been dropped, then the authority would be obliged to return the deeds. Deeds in question. Paragraph. Learned advocate representing the state respondents is directed to obtain instruction from the Inspector General of Registration and the Commissioner of Stamp Revenue as regards return of the deed of the petitioner. Release the matter on 27th. Obtain instruction. This is taken on record.
We appear for the petition.
Yes.
No.
I appear on behalf of the state, madam.
Now, our basic grievance is non-renewal of our license. And we once came before this honorable court. The honorable court directed us that I should take the alternative remedy forum first. Lord, we have had the alternative forum, and the appellate authority has passed an order that is at page 94.
Yes.
Now, need not be troubled, my lord, with the first page brief facts and others. Then kindly come to, my lord, page 2, appearance of appellant. Then lordship may skip over the first paragraph. Then the bullet 1, forest license was issued on behalf of the appellant on 23rd February 1988. It should not be on behalf of, it should be for the appellant. Anyway, on 9th February 2011, the managing director of the appellant company made a representation for renewal of license. Despite making several representations, the appellant later came to know that the forest license in question had been cancelled by a notification dated 27 December 2016. Then the divisional forest officer has recommended the matter of the appellant to the member secretary of state level committee by letter dated July 24 and June 27 for grant of license. The divisional commissioner is the first foundational authority. They decide our infrastructure and other things. After the same, on 6th January 2022, the appellant was called for hearing by the divisional forest officer. By order dated so and so, prayer for renewal of license was rejected. But for grant of license, issue still remains valid. Against such order of rejection, the instant writ petition so and so, lordship need not be troubled. Then kindly order with reasons. Whereas forest license such and such was cancelled on 27 December 2016 by the authorized officer, whereas the cancelled license cannot be renewed. But I do find some logic behind it. But the recommendation was for grant of license. Therefore, they ought to have considered
without
that
revoking the order of cancellation.
That was cancelled. Therefore, that license now becomes void. Because of now,
grant of license means fresh license.
Fresh license. Because I have the infrastructure, I might not have the permission to run because of lack of license.
Yes.
That license stood cancelled, they say.
Yes.
Very well cancelled. But that does not prohibit them to consider my fresh application for license. That was recommended by the division officer. Now, this is the area where, my lord, the authority have failed. Very short and precisely, this is the issue before the court. If you say that the renewal...
You are not challenging the cancellation.
This is a temporary period. Lordship knows it has to renew year to year. Once it's cancelled, that means that license is dead. Now you can have a fresh one.
Show me.
Their point is that they cancelled...
Oh, 1 minute. Here, the second bullet point you read out that the DFO has recommended the matter of the appellant to the member secretary. 2014 and 2017 for grant. So it is a mere recommendation.
Yeah, that's true. No doubt about
my lord,
no decision has been taken as of now.
But he is
Appellant
not
was
the
called for
decision-making
a
authority.
hearing. Renewal prayer cancelled. Yes, please.
my lord. This is a license for a second one. My lord,
Second one means?
he has two licenses.
Alright.
My lord. He has two, my lord, factory. One is, my lord, for in the year 1988, one license was given by the Nodia Murshidabad division, that is Calcutta, Messrs. Calcutta Veneer Industries Private Limited. My lord, this license was renewed up till 1997.
Thereafter, your lordship kindly come to paragraph 3 of the writ petition. They themselves have stated. Paragraph 4, rather. Your page 3, first volume, your petitioner states that under the then prevailing situation, the management of the petitioner company was not able to run the unit at Kalyani, that is Veneer, Calcutta Veneer. They themselves stopped. License was up till 1997. Therefore, the management of the petitioner company had arranged a piece of land at Falakata under Jalpaiguri Forest Division, Jalpaiguri, where the petitioner would ship the machinery. So they wanted to ship this factory to Jalpaiguri. They have shifted it without informing the divisional authority of the Forest Divisional Authority of the Nadia Murshidabad Division. They shifted it to the Falakata. Then they, in the Jalpaiguri Division, they have not informed. They started business. Then in the year
started business?
Yes.
Without a license?
Without license. And my lord, in the year 2011, they first applied for, in the name of, my lord, they applied to, in the year, on, my lord, 10th of August, Sri Sanjeevan Chatterjee, the director of this, my lord, Calcutta Veneer, had submitted an application for secondary license before the divisional forest officer. So first license was cancelled. It was not renewed after 1997. Then it was shifted to Jalpaiguri. Then he applied on 10th of August 2011 for granting of license. It is perhaps that the second paragraph mentioned about the granting of license of this in the name of Messrs. Kastua Uddhog. This is their company, which was approved by the 5th state level committee, Wood-Based Industries West Bengal, meeting held on 13/6/2022.
Where are you reading?
Yeah, this is reading from my statement.
Oh.
May I come back with my lord an affidavit? May I say all these things with an affidavit and documents, my lord?
No, there is an application pending for grant of license. You consider and dispose it of what more to be done.
What, my lord, already license has already been cancelled, my lord. This is cancelled in the year 1997. It's a date.
He wants a new one.
It cannot be revived after 10-20 years, my lord.
He wants a new license.
New license has already been granted in the name of Messrs. Kastua Uddhog. He has transferred all his machinery to their Jalpaiguri, and Jalpaiguri they applied for license, and that has been given.
So this is for which one? Veneer?
For Calcutta Veneer. This is the dead one, which they have shifted.
Two different companies.
Two different companies.
Different establishment.
In the name of a different establishment, they shifted their machineries and start a new one in the new name and applied for license. License has been granted.
So
for the old one, license has already been expired in the year 1997. Thereafter, no step has been taken in by the. But in the year 2000, my lord, thereafter, my lord, they applied for renewal in the meantime, and that has been cancelled. It was stated that, my lord.
So now he wants a new one.
New one.
Now he wants a new one.
No, he wants
the
renewal of the old license.
He doesn't want renewal.
No, my lord, your lordship, kindly have a look to the, my lord.
Prayer. What is the prayer? Prayer is for renewal or for grant of fresh license?
Renewal. Your lordship, kindly have a look to Your lordship, kindly come to page 95 of the writ application. Order.
Yes. You are praying for cancellation of the cancellation notification.
Yes.
That means
he applied for renewal, that has been cancelled. They have challenged the same.
The way you placed it and the prayer, they don't go together.
No, not prayer. I place it, my lord, when I find that the renewal may not be feasible because of cancellation.
In that case, your writ petition
But,
goes.
but at the same time, my lord, these prayers can be, my lord, molded by the court also.
No, no,
When I-
molded to what extent? Your specific prayer is for cancellation of the cancellation notification, which was in
Lord, this omnibus
2016.
prayer is there, always in the writ petition.
No, that is
Appropriate
different.
order, kindly sees, my lord, my prayers are there.
The writ petition ought to have been settled by you prior to the filing. That is not done. It cannot be done. How much can you improve at the time of making arguments? It was not. The premise of filing the writ petition was different. Today's submission is something different, right? Suppose what you said, that you want consideration of your application. Where is your application?
My lord, that was recommended by the authority concerned, that is mentioned.
No, only mentioning will not do. I need to see your application. Where is your application?
I shall, my lord, bring that, my lord, your lordship, not next.
How? By supplementary?
By supplementary.
Again, something else.
Or handing over to the court.
No, 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 no.
Then my lord will kindly give me.
Cancellation remains. You are challenging the cancellation. Yeah. At the same time, you want to make your application for a fresh grant.
That has been cancelled in the year 27 December 2016. It was cancelled.
Lord, I am not disputing the facts. My lord, the cancelled cannot be renewed. I have accepted this proposition. I am not also contesting that. But that does not prevent the state from considering fresh issuance of license. License is always.
Where is the application?
On the basis there of application, the application copy is not there. But here the authority, the
No,
base
only
authority.
one line grant, and the submission is that this grant was in respect of the other license that you have.
Probably he's confused. There are two establishments.
Yes, this grant is for the other establishment. This is what his instruction is.
Yes, yes, my lord.
Here the
it has Calcutta veneer has been cancelled in the year 2016.
The Calcutta veneer.
Yes.
Therefore, they cannot say that this is representative issued for another.
No, my lord.
Additional Forest Officer, Jalpaiguri Division has recommended the matter of
the second
of the
one was
appellant.
given in the year 2024.
Where is the unit or the factory? Is it in Jalpaiguri?
Yes.
Why are you coming here?
Good.
Today you are absolutely on several counts. You cannot proceed with this. So the writ petition is to be dismissed.
No, but the order I am told is not by within the Jalpaiguri Division jurisdiction. This is by Murshidabad. Appellate.
How can Murshidabad go to Jalpaiguri?
Appellate authority.
Where is the appellate authority?
Kindly come to page 96. The order is by the appellate authority.
Yes,
That means in the Murshidabad district.
Yes, relating to Murshidabad unit.
This court has jurisdiction.
So, see, the grant possibly is not in Murshidabad. I do not know because the grant is in Jalpaiguri. This is what he says.
Jalpaiguri was granted on 14th September 2023.
No,
the second unit license was granted.
Second unit. He admits it.
Yes, second unit, and he has come before your
As
lordship for
regards
the
Murshidabad,
renewal of
there is
Murshidabad
no
unit.
recommendation for grant. Murshidabad, the cancellation stands.
Lord, we have two establishments. One is a proprietorship firm.
Forget everything. Just show me the law that in case your license is cancelled for once, there is no bar in making application for obtaining fresh license. Show me the law, get it done.
Kindly come to the act now.
Yes, show me the act. You also.
Yes, my lord.
Suppose one is cancelled.
Yes.
Does it 2016 it was
If
cancelled?
it is cancelled, my lord, general thinking, my lord, he
can
can apply for fresh one that can be considered by the department. But
I
he has
shall bring
never
the
made
application.
any.
I will show that application was there. That was recommended by the base authority, recommending authority saying it is recommended for the.
So that is a very integral part of your writ
That is
petition. It's
unfortunate.
not here.
I shall think that application. I shall also hand over a copy to him. Let him check it.
So the draft was made without keeping things clear.
But anyway,
Very confused draft. Please come.
Let learned friend, my lord, withdraw this application and come up with a fresh application with all the papers, my lord.
I will immediately.
Yes, he accepts your proposal.
Provided
Prior to making submission, you should know how it will be accepted or whether it will be refused.
It is.
He will immediately accept the proposal.
then I am not making.
Achha. The order dated 18th July 2024, passed by the Appellate Authority, West Bengal, WBI, Nodia, hyphen, Murshidabad district, and the Conservator of Forest and Joint Director, Sundarban Biosphere Reserve, is impugned in the instant writ petition. Stop. Paragraph. It appears therefrom that the license of the petitioner stood cancelled by the authority on 27th December 2016. Stop. The petitioner intends to obtain a fresh license. Stop. Submission paragraph. The submission is that application for fresh license was made, but the same has inadvertently
But
not
nowhere
been
in the
annexed
pleadings they have
to the
stated
writ
so.
petition.
In the writ petition, nowhere in the pleadings, my lord.
That's it. Leave has been sought to file a supplementary affidavit annexing documents in support of the submission that an application for fresh license is pending consideration. Stop. The aforesaid submission made by the petitioner is opposed by the learned advocate representing the state respondents. Stop. It has been submitted that in the entire writ petition, there is no mention about pendency of an application seeking grant of fresh license. Paragraph. Be that as
Rather,
it
they
may.
have challenged the
Be that as it
appellate
may.
authority's order, which is culminated
The
from
leave
the
sought for filing the supplementary affidavit stands allowed. Stop. Let the supplementary affidavit be prepared and circulated. How soon?
2 weeks.
2 weeks by 26th. Release the matter on 29th August.
लोग आगे থেকে দিয়ে দিও তাহলে আবার
My lord, may I have your lordship's leave to indicate one thing, my lord. On item number 46 appearing in your lordship's list, my lord, another petitioner is present, my lord. The petitioner is above 8 years old, my lord. I had a talk with the other side, my lord. If your lordship can take up the matter at any time.
The petitioner is present.
Petitioner is
Who directed the petitioner to? Is there a direction for personal appearance? Then call the list, please.
Item number 17.
I beg to appear. Lord, I am not the state respondent, but I got the report.
My lord, in this petition, my lord, the petitioner, my lord, through his advocate applied for certified copy of a sale deed. But the office was not giving because, my lord, they say, my lord, it cannot be found and everything. That is why, my lord, this petition has been filed. And it is a book one document, my lord, it is general document, it can be supplied to anybody.
Getting instruction from the office of the search committee was
Copy there.
It's an instruction.
no records.
No records.
It has been diarized before the Islampur police station, and accordingly, no certified copy relating to the deeds can be given.
I have a Xerox copy.
Committee was also formed.
A committee has also been formed to look into it.
Can I get a copy of the report?
Page
Come
5,
back
my
with instruction, my lord.
Please come. Where's your application? Application for
Yes.
obtaining certified copy?
Two letters have been sent by the advocates of the petitioner, page 12 and 13.
The petitioner intends to obtain certain information. Intends to obtain certified copy of the deed in respect of certain plots of land. Stop. The same not been provided to the petitioner, the instant writ petition has been filed. Paragraph. Learned advocate representing the state respondents has obtained instruction from the additional district sub-registrar, GOAS, Murshidabad, dated 24th September 2024, which mentions that parts of pages in
volume as well as
both volumes and index related to deed bearing number 1851/1993 and 1852/1984, 1983 and 1984 are missing. 83 and 84. 1851, 1983, 1852, 1984 are missing. Stop. Simultaneous missing of parts of both volume and index has raised doubts, and the same was informed to the District Registrar Murshidabad. Stop. A search committee on the instruction of the District Registrar was formed, headed by the head assistant, to search the missing parts. Stop. Despite search, the missing parts were not found. Stop. The same has been registered before the Islampur police station by lodging a general diary. Stop. No certified copy relating to the aforesaid deeds were issued from the office of the ADSR GOAS. Stop. Paragraph. The district sub-registrar is directed to look into the issue and take steps for consideration of the petitioner's prayer for grant of certified copy of the subject deeds. Heat petition stands disposed of.
My lord, may I get a copy of the
instruction be kept with the record?
Instruction is written with the records. Whatever is there, I have in verbatim recorded in the order.
even that for satisfaction some?
For whose satisfaction?
My lord, may I get a copy on my
I have recorded in the order for your benefit.
still, my lord? Sometime, my lord, it requires.
There is no still. If the order is recorded so that nobody can say anything about it. The ADSR will also be there.
For enhancement of monetary instructions.
At my cost, I will take a xerox.
No, no, it's not a matter of your
matter,
cost.
you'll take up or I have the other the
Passport
13
matter
13
usually is called after you.
Then your lordship take it on next day, my lord.
All right, next day.
Not today, my lord. No, I'm grateful to your lordship. 13, my lord, not today, my lord.
18.
My lord, I am appearing for the respondent number 1 to 5.
Yes.
Good.
My lord, আমি in person করতে এসেছি।
Yes.
My lord, the petitioner, my lord, participated in a tender.
My lord, before my learned friend begins, my lord, I have been made a party. I am Chandan Gupta, but no copy of the writ petition has been served upon me.
My lord, initially, my lord, we have sent, my lord, and my lord, email was also made, my lord.
Yes.
Give a copy.
But I am
Give a
handing over.
copy.
Now, my lord, it will help him also. My
All
lord,
right.
my lord, tender document is at page 21. My lord,
Yes.
it is for 1 year. Thereafter, renewable clause is there for 3 years. Now,
Hmm.
my lord, renewable clause is at page 41 of the tender document.
Hmm.
My lord, page 41, 6.7, my lord, at the top.
Yes.
Now, my lord, what happened, my lord? In this tender, my lord, I participated along with the private respondents. Now, my lord, there was a tie. Now, my lord, there is a tie, my lord, in respect of tie, my lord, your lordship will find, my lord, the clause at page 56.
Yes.
56, 25.1.
Hmm.
Subject to the GIB. GIB is, my lord, general instruction to bidders.
Hmm.
Under clause 24 above, the contract will be awarded to the lowest evaluated responsive bidder per health facility. The list of successful bidders shall be uploaded online. In case of tie, only one bidder should be selected.
How?
Yes. Now, my lord, on this day, my lord, there is a memo of the government of West Bengal. My lord, it says, my lord, the memo is at page, my lord, 71.
Hmm.
My lord, the operating portion is at page 73.
Yes.
Here, my lord, your lordship will find at the top in case of tie bid.
Hmm.
Now, my lord, very second paragraph. Keeping the discovered L1 rate at ceiling, seal bids may be invited from the L1 bidders, and out of this, the lowest bidder may be selected. Now, my lord, what happens if, my lord, the L1 bidders do not want to reduce the rate? In that case, my lord, point A, my lord, says the work may be distributed equally among the L1 bidders. Now, my lord, here what happened? My lord, 3 bidders were selected. My lord, L1. My lord, I, along with the 2 other private respondents, my lord, we were called for a meeting. My lord, your lordship will find that, my lord, page. Page 70, my lord.
70.
Yes, my lord.
Yes.
Here, my lord, your lordship will find 3 parties were addressed. My lord, there was a meeting held, my lord. In that meeting, it was decided, my lord, no rejection till date. It was decided, my lord, the work will be divided. In my lord, 3 bidders, 4 months each every year. Now, my lord, I filed a writ petition. My lord, when my turn was coming, my lord, they didn't issue any work order to me. So, my lord, I made a representation. I asked for the work order of my turn, my lord. This is, my lord, pending since.
And how are turns decided?
My lord, terms are decided, my lord, as this is for 1 year and thereafter renewable for 3 years. My lord, as there are 3 L1 bidders, 4 months each L1 bidder will perform.
Who will be the first performer?
My
How
lord,
is
the
it
person
decided?
who has got the work order now, he will function for the first term, and thereafter I will perform. My lord, I have also a case, my lord, citation, my lord, in which, my lord, this has been permitted by this honorable court. My lord, the court time frame that from such and such time this person has worked. Now the second bidder will work, and thereafter from such and such date the third bidder will work.
No, it's all right. Now, what is your prayer in the writ petition?
Consider the representation.
Demand of work order, page 78.
No, my lord, my prayer is at page 12. My lord, yes, my lord, I made a representation demanding the work order for the 4 months which I will work, which I am entitled to get as a L1 bidder. So, my lord, this is my prayer before the authority, my lord, to give me the work
And
order.
Chandan has performed his part of the work?
That he can say. I do not know that who has performed. I do not know, my lord. One of the L1 is working, that I know.
Now, my lord, I had an instruction.
What does it say?
So it says, my lord,
that no agreement decision was arrived at, meeting so and so date, different that. Chandan Sengupta firm, who was awarded the contract, is the most competent firm in respect of the credentials compared to the other firm. Hence, there was no violation of government rules. Thereafter, no violation of the government rules were made in awarding this contract. This contract was awarded to the firm with highest credentials with the order number dated 5/3/2024. The contract was awarded to the firm highest credentials or 5/2024. No illegal action was taken by the government authority in this matter. So this is what
1 minute. Where from do you say that there was tie bid?
Tie bid. Milord, that is why, Milord, we three were called. We three were called. Milord,
No,
this
the
is,
instruction that is being forwarded says that he has the best credentials.
Milord, that may
And
be.
there is no mention of a tie in
I
the
tell you,
entire instruction.
Milord, kindly see this. Milord, this is L1, 3 L1s.
I do not know. Maybe thereafter a reduction of rates was there.
That was not done. I tell you, Lordship, that has not, Milord, fallen. Milord, what I say, Milord, they have said that better credentials. Does that reflect in the tender document? Milord, they cannot change the rule of the game. They have said that one bidder should be selected. Then how?
That is what has been done.
Milord, yes, Milord, their process should be followed. Process is that memorandum that is a government of West
No, show how. Where from are you saying that it is a tie bid?
Milord, Milord, kindly see, Milord, page 25, Milord, I have shown, Milord, that one bidder should be selected.
Where is the proof to show that there was a tie?
Hi, Milord, kindly see this.
No, it's not a part of the writ petition.
Milord, it is not a part of the writ petition below, but Milord, the tender ID will match.
Listen, whatever you've got to submit and whatever the CMOH has submitted.
Yes.
There is not a single mention of a tie.
Milord, kindly.
Now, if you want to add something, then the further instruction will be required.
Kindly takes up page 71. Milord, if, Milord, there is no tie, Milord, why three bidders will be called?
I do not know.
Milord, that is the reason, Milord, the three bidders were called. I have stated this on affidavit that there was a tie. Because that time it was not available in.
It is not necessarily that only in tie 3 persons or 4 persons has to be called. The authority wanted to check who is the best person to whom the contract can be awarded, and that is the reason it may have been.
Milord,
they may have been called.
according to Milord, my instruction, Milord, there were 4 bidders.
Whatever, please come.
Milord, there were 4 bidders.
Milord, if Lordship takes page 73 once, Milord, it has been specified in page 73, Milord. Kindly takes page 73 once, Milord.
Yes.
If none of the L1 bidders is ready to accept the reduced quantity, the bidders with higher credential based on the following parameters may be selected among the L1 bidders in the following manner. This has been
following manner.
Following manner is there, Milord, in case of supply of goods.
So that will be divided. The following first condition is division.
The matter relates to the notice inviting e-tender dated 28th November 2023. Vide memo number page 21. Copy করবেন দেখে দেখে একটু ভুললা লিখবেন না একদম by the member secretary, comma DH and FWS and Chief Medical Officer of Health, Paschim Mendipur. ঠিক আছে? The petitioner claims the petitioner participated in the tender process along with the private respondent. Private respondent. Respondents.
Kindly take the page 22 once. 22 once, Milord.
Page 22.
Yes, Milord.
Yes.
Milord, kindly see 4 persons were, Milord, allowed in the financial bid, admitted. Milord, this shows, Milord, that there was a tie, Milord.
No.
Page 73, Milord, clarifies that.
Acha. Private respondents stuff. The petitioner claims that there was a tie in the bidding process. Stop. All the 3 L1 bidders were directed to appear for a hearing, and a decision was taken by the authority to distribute the work equally among the three bidders. Stop. Submission is that after one of the bidders has completed his tenure of the contract, the next next work order is liable to be issued in favor of the petitioner. Stop. A representation demanding work has been made before the CMOH in August 24, and the same is alleged to be kept pending. Stop. Learned advocate representing the private respondent number 5 submits that his client was the lowest bidder, and accordingly work order has been issued in favor of his client, and the private respondent number 5 is performing the work. Stop. Next. Learned advocate representing the state respondents has obtained instruction from the Chief Medical Officer of Health, Paschim Mednipur, in December 24. Stop. The instruction clearly records that no agreement and a decision was arrived at in the meeting due to the different opinion. Stop. The respondent number 5 was awarded the contract as he was found to be the most competent in respect of the credentials submitted. Stop. The contract was awarded in favor of the private respondent number 5 in March 2024. Stop. Next. The submission made by the petitioner that there was a tie bid and a decision was taken to provide work equally to all the bidders is not is denied by the respondent authority. Stop. Paragraph. As it appears that there are disputed questions of facts involved in the writ petition, the writ court will not be the competent forum to adjudicate the same. Stop. The writ petition accordingly fails and is hereby dismissed.
Sir, let my representation be considered, at least.
They do not accept that there was a...
Let them say by way of an order, my lord, so that I can challenge it, my lord. Let my representation be considered.
Service is taken on record.
Get to that.
It is two.
Number 20.
Yes. 20 also no copy, sir.
20, my lord, similar matter, my lord. My lord, I tell your lordship, my lord, here, my lord, I have annexed that I am the L1. There are two L1. My lord, page 66.
Show me that there was a consensus, there was a decision taken in the meeting to distribute
That, my
work.
lord, nothing has been given to us.
What can be
I
done?
can show, my lord, that I was the L1. My lord, kindly see page 66 once. Well, page 66, my lord, I have annexed, my lord, that I, along with the private respondent, is the L1. Now, my lord, thereafter, here also, my lord, a meeting was called for. And, my lord, these standard documents specifically say that in case of a tie bid, government norms will be followed. My lord, as per the memo, there should be, first, my lord, there should be a tie bid. If there is no tie.
What is your instruction over here?
My lord, there was a tie.
Yes.
And my lord, because of the tie, the further proceeding which is required under the memo has been followed. My lord, they are required, my lord, to distribute the work where it is possible. Now, my lord, if they do not reach that consensus, then another 3 mechanism is given how the person will be selected.
Right.
Now, rightly, as a prudent businessman, the private respondent, knowing that he will fall under the other three parameters, he has not chosen for the division of work.
All right.
Therefore, my lord, going by applying the three parameters, which
Best
are
credentials.
best having the private respondent having the best credential has been given the work, and the fact that there is no consensus between the bidding parties, well, that is recorded in our contemporaneous minutes, that there is no consensus among the bidders.
If at all, my lord, this is the stand of the state, they should have communicated to me. But nothing has been communicated.
Where is the communication made to an unsuccessful bidder?
My lord, the difficulty is that, my lord, I have been declared as the L1 bidder, and thereafter, my lord,
Thereafter, whatever is
they are giving the tenders, my lord, to their selected candidates.
I understand, but then it cannot be done now.
My lord, they
Please
should
come.
follow the memo at least. My lord, this is their memo.
এটাতে আগে যে টেন্ডার নাম্বারটা বললাম, এটা টেন্ডার নাম্বারটা হচ্ছে 18. 21st February 2024. Memo number is such and such. ঠিক আছে? The petitioner claims the petitioner participated in tender process along with the private respondent. Stop. The petitioner and the private respondent both emerged as L1 bidder. Stop. Learned advocate for the petitioner asserts that that a meeting was called where the petitioner and the private respondent both appeared, and there was a consensus for division of work between the two L1 bidders. Stop. The petitioner submits that as the private respondent has concluded his term, accordingly, the work order is liable to be issued in favor of the petitioner. Stop. এরপর আগের মামলাটাতে প্রাইভেট রেসপন্স সেম বক্তব্য state give your instruction and can keep it on record.
Fine. And my lord, I'll just point out, my lord, at the handwritten page number 10, my learned friend's client had was present, and he was aware that the decisions are being taken.
Meeting,
my lord. Signature is at page 10. The decision is page 11, my lord. There's some red marking, my lord. Kindly pardon. The second last paragraph in the first page records, my lord, our steps.
State respondents has obtained instruction
May I get a copy of
from the Chief Medical Officer of Health, Paschim Medinipur. It appears therefrom that in the meeting, the parties did not agree to reduce their bid amount. Stop. The authority followed the financial norms order number 2320-F within bracket. What is it, V or X?
But,
dated 7th June 2022. Subclause A within bracket small I.
It is Y, my lord. It's annexed to my
FY.
Yes.
All right. F within bracket Y. 7th June 22?
7th June 22. I have annexed.
All right. Okay. And the credentials of the private respondent being better, comma, the work order, the private respondent was treated as the lowest bidder and work order has been issued in his favor. Stop. The private respondent is performing his work in terms of the work order issued. Stop. The submission of the petitioner that there was a consensus in the meeting for distribution of work is denied by the respondents. The same also does not appear from the document of financial evaluation prepared by the tender issuing authority, where the petitioner was also present and his signature recorded. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Last facility of services. But 22 will also be similar.
Well, 20, 21, 22, both are similar.
21?
21.
The bid number or the tender number will be different. They keep
Number
changing.
21.
Yes.
Tender cancel, my lord, in 21. In item number 21.
21, my lord, this is my instruction, my lord.
Please give. Page 19. 6th February 2024. Memo number at CMOH Paschim Medinipur. আচ্ছা লিখুন Are you aware of the cancellation?
No, my lord.
No? All right. The matter relates to the e-tender notice being number such and such. দেখে নেবেন যেটা বললাম Learned advocate representing the state respondents has produced before this court a memo being number dated 4th October 2024 issued by the Chief Medical Officer of Health Paschim Medinipur, wherein it is mentioned that the tender notice dated 6th February 2024 has been cancelled due to unavoidable technical reasons. Stop. Further e-tender notice will be published soon. Stop. Paragraph, as it appears that the subject tender process has been cancelled by the authority. Accordingly, no order need be passed in the instant writ petition. The writ petition stands disposed of. Next.
22 is similar to 20, my lord, but the meeting date is different.
Meeting date is different. Give the date and your instruction also. His signature is there?
Signature of for Das facility, one Devmallo Kumar appeared.
In the other one Vishwanath Das was there?
Yes, my lord. Here, my lord, for Das facility, Devmallo Kumar has put his
All right.
signature.
Give.
Page 14 of the instructions.
সেম হবে ওই ই-টেন্ডার নোটিস নাম্বারটা ডিফারেন্ট হবে এই যে পেজ 19 28 11 23 মেমো নাম্বার সার্চ ঠিক আছে আর তো ঠিকই আছে মিটিং এর ডেট কি আগেরটাতে বলেছিলাম ঠিক আছে কিপ দিস অন রেকর্ড অলরাইট ডিসপোজড ডিসপোজ না ডিসমিস যা হয়ে যাবে সেম অ্যাজ 20 dismissed dismissed 21 dispose অন্যগুলো dismiss
Milord, I am appearing on behalf of the petitioner.
Rashmi, I'm for the state.
Milord, state.
Relating to
Yes, I am being candid, Milord.
Corporation Lordship.
This has been wrongly filed before the
yes
this
Group 5 matter Lordship.
group 5
this would have been a good five, madam. This is a change brief, your lordship. Just yesterday we received the brief and I found out that it relates to group 5 matter, Milord.
group 5
And Milord, kindly allow me leave to
yes
amend
leave to amend the presentation form front sheet
Great. I'm for the respondent, my lord. Milord, also a liberty to file my wakalatnama in the course of the day because we received it this morning only.
all right Leave is granted to the advocate on record of the petitioner to file fresh wakalatnama in the department in the course of the day.
Grateful.
Grateful, ma'am.
By course of tomorrow করে দিন, আজকে এমনিতেই 3:30 বেজে গেছে।
24,
I'm for the petitioner, Your Lordship. I'm appearing on behalf of Union of India, Your Lordship. Learned ASG is appearing. We not received any notice for upgradation, Your Lordship. No, Your Lordship, I have served the upgradation notice, Your Lordship. I'm This is the
All right.
notice for upgradation, Your Lordship, has not been received upon us. This is for the upgradation.
Where did you serve the notice? To the Union of India, where was it served? Did you serve the State Bank of India?
We have served the State Bank.
And the Union of India also?
Yes, yes, Your Lordship. We have served all the respondents, Your Lordship.
Where was the Union of India notice served? Which place?
Your Lordship, if you kindly fixes the matter next week, any day other than Monday, Your Lordship.
None appears on behalf of the State Bank of India. Stop affidavit of service filed in court is taken on record. Release the matter on 27th of August. Let fresh notice be served upon the non-appearing respondent.
Could answer the petition question. Both the affidavit of service, one initial service, another for application.
My lord, I'm appearing for respondent numbers 2, 3, and 4. Lord, pray your leave to appear virtually.
Yes.
Lord, I have a current account, under the Indasan Bank. There is a disclosure, that my account will be freeze, at page 21 because of two transactions, one 3,600 rupees, another 400. So total amounting to rupees 4,000. This, according to the bank, this was made, in relation to some cyber crime, this amount has came to my account. That's why this has been freeze, page 21 of my lord's brief. If it is not so legible, I have prepared.
No, it's all right. Then what has happened?
Thereafter, there was a communication. I again, as per page 23 and 24, as per the direction of the cybercrime department, I forwarded the amount of 4,000 to the account of someone has been directed by the cybercrime department. And thereafter, the defreeze order was being made at page 27 of my lord's brief. This was directed to be defreeze my account. Kindly now turns over the page to page 28. This is a communication whereby it has been from the deputy branch manager. It's directing that we would like to inform you that we have received a notice from Cyber Cell Madhya Pradesh advising and authorizing us to lien your account number such and such with immediate effect as a part of procedural review. This was done in 2023. 22nd of May 2023. We wrote several letters, thereafter also, kindly turns over the page of page 29. The same communication to ensure the compliance and abiding the acting of the instruction of NCRP Madhya Pradesh Cyber Cell. We have lien your account number such and such and request you to refrain from undertaking any banking operation with regard to this account in particular. Now, I have.
How much money you have in this account?
It's about 17 or 18 lakh current account,
Yes.
And thereafter, I wrote a letter, my junior has made a mistake, under the Right to Information Act, I applied for from the concerned police station. This reply has been come up, wherein they have themselves intimated that no such communication from their end has been made to the banking authority to lien my account. This is after 2023 communication.
So you want your account to be defreezed,
My lord, I
the
want
lien to be removed.
lien to be removed because defreeze was made, my lord,
Already
by the
done.
bank. My lord, let a bank come and take a stand. Why
Alright,
they are
let me hear the bank.
My lord, in this matter, I have two branches of submission. The first branch, my lord, is that they have come before your lordship without exploring the alternate remedy which lies before the banking ombudsman, my lord. This is one point which your lordship will, I pray for your lordship to consider while hearing the matter. The second point on merits, my lord, this defreezing is not restricted to only the complaints made by the Madhya Pradesh police. In between, what they have suppressed in this writ petition is that the bank, under the master directions of a circular of 2016 issued by the RBI, my lord, had written to them asking for the source of funds because there were several high value transactions in this account, and the bank has a duty under the directions to question the customer if the transactions appear to be not balancing with the balance left in the account and so on. My lord, I have that circular. If your lordship is keen to see, my junior is there in court. He can present it. It is at, it's starts from page 20. No, 38, my lord. Page 38 is the relevant portion. It's a due diligence which the bank has to take on. And they have suppressed the letter that the bank had sent to them.
It's
And
better
they,
you file a report and disclose all these things so that the
yes, may I file an
petitioner
affidavit, your lordship? Affidavit?
My lord, may I submit only one fact, my lord? My lord, the petitioner, in fact, had made a complaint to the ombudsman. My lord, I represent the ombudsman. My lord, by an order of 1st October 2024, that complaint has been disposed of. My lord, since this was filed by the petitioner, not himself, but through an advocate, in terms of the regulation, such application is barred. So, my lord, under this regulation, this was barred. My lord, may I hand over that order passed by the ombudsman, my lord?
Yes. And there is nothing disclosed in the writ petition regarding approaching the ombudsman. And that is the reason the IndusInd Bank is raising this issue. Your client has not disclosed you all facts.
1st October 2024.
I get it. The petitioner seeks for a direction upon the IndusInd Bank to remove the lien that has been made over the current bank account of the petitioner. Stop paragraph. Learned advocate representing the IndusInd Bank submits that there has been suppression of material facts in the writ petition. Stop. Prayer has been made to permit the bank to file an affidavit disclosing all facts. Stop. Learned advocate representing the Reserve Bank of India submits that the petitioner, through the learned advocate, petitioner, comma, through the learned advocate, comma, approached the banking ombudsman. But the complaint of the petitioner was closed as the same was lodged through the learned advocate, which is a bar under the scheme. Stop paragraph. For effective adjudication of the instant list, comma, the IndusInd Bank is directed to file a report by way of affidavit disclosing all facts and figures with supporting documents. Stop. Such affidavit shall be prepared and circulated by 3rd September. 3rd September. On 16th of September, it will be open for the petitioner to file exception to the affidavit filed by the bank prior to the returnable date.
Grateful. Senior friend, my lord, the petition is affirmed on 30th September. My lord, this order is of 1st October. So perhaps this was.
No, but then the application was made before the ombudsman. This could have been made. You take this back. I have recorded your submission. Service is taken on record. Eta ferot diye deben. Oporerta ferot jabe.
Number 26. My lord, I am appearing on behalf of the petitioner. This petitioner is a specially abled girl with 70% disability, and she was brutally attacked by acid. My lord, kindly directs the state advocate whether any instruction is there or not.
What is the prayer?
Our prayer was to receive at least rupees 8 lakhs, my lord, as my
Victim
lord,
compensation.
yes, as compensation. And my lord, there is another prayer to get a monthly pension of rupees 10,000 to maintain herself. My lord, on 17th of April 2025, I made a specific prayer before Nodia District Legal Services Authority. But till date, we have not received any instruction therefrom.
Where is your representation?
My lord, after filing
After filing of the
my
writ
lord, we have
petition.
referred. My lord.
You can bring that by way of a supplementary,
My lord.
so that the court can take note of it and pass necessary order. But in the meantime,
Milord,
yes.
acid attack victim compensation milord shall be dealt by the state legal salsa.
I see the salsa is
They have
not a
they have a
party.
different set of lawyers.
Oh, salsa is a party,
Yes,
but
a
no,
party.
salsa is not
No, I
represented.
submit that they have a separate set of lawyers.
Yes.
Yes, Shoma Bondhu.
Yes, my lord.
Yes, she appears.
She appears.
Lordship.
She is not. Did you give the notice of upgradation?
But we have not upgraded this matter, my lord. This has come automatically.
No, it cannot be.
This has come automatically, my lord.
Janababu?
আমরা তো কোনো নোটিশ দিই
চেক করে দেখে নেবেন তো হ্যাঁ
এটা কি মান্থলি লিস্টে ছিল
yes yes you also did not get any notice of upgradation
454
No, milord. Nothing.
454
454 in the monthly list upgradation হয়েছিল তো
454 আমরা তাহলে ভুল করে অন্য
you know that is
my lord be that as it may we shall serve a notice upon
since it has come up and since it's victim compensation I do not want to delist it please come none represents the state legal services authority stop let notice be served upon Miss Shoma Bondhu who usually represents SLSA before this court stop learned advocate for SLSA shall take specific instruction in this matter. Stop. Next Wednesday, 20th.
Grateful.
Grateful.
It has been mentioned. এটা মেনশন হয়েছিল তো None appears on behalf of the petitioner at the time of call. তার আগে একটু লিখবেন যে the matter was mentioned citing urgency. Stop. The same has been upgraded in the list. None appears on behalf of the petitioner at the time of call. List the matter on 1st September.
This is my application. This is my notice of upgradation to the state and corporation also.
If your other side is here, then the notice is not very important.
But
If
this is
if
my
it is
affidavit
not
of
here,
service.
then only the notice, affidavit of
is-
service and everything becomes important.
This matter is filed in group 5.
No, that is.
Why here then?
Kindly come to page 30.
This has to be corrected.
The corporation.
In my copy, it is mentioned residuary.
Well, service copy group 5.
My lord, page 31 is this, my lord. The commissioner, my lord, directed the joint commissioner to intimate the, my lord, secretary, my lord, Department of Urban Development to sanction the fund so that they can pay to the petitioner. My lord, it was the observation.
But then it should go before the group 5 bench, isn't
No, my
it?
lord, that is
What
the
no?
urban development is cannot come under the group 5. Lordship kindly direct the-
Vidhannagar Municipal Corporation is there.
No, they have already sent to the, my lord, intimated the urban development department. Lordship kindly direct them.
Who are you representing, the state or the corporation?
Corporation, my lord.
State
Then
is there. I have already served state.
who?
Mr. Soumitra
বন্দ্যোপাধ্যায়, সৌগত মিত্র?
সৌগত মিত্র একটু দেবেন তো এটা নোটিস।
No, he's here. Are you aware of this matter?
Yes, my lord.
What yes, my lord?
Prayer of the petitioners.
Lordship kindly direct the urban development bill to sanction the fund and send to the corporation.
No, how can
Prayer of the
Prayer of the petition. As in instruction নিয়েছো? বলে?
Please come. The petitioner seeks payment of the work executed by it. Stop. It appears that the Commissioner Vidhannagar Municipal Corporation What is the date of this page 31? I cannot read it.
Page 31, there is the date is this, page
22nd
22nd
April 22 communicated.
that is the-
Communicated.
yes, communicated. That is the page 30. Let's since then they didn't sanction the fund.
আচ্ছা কি বললাম? Communicated to the petitioner the reasoned order dated communicated to the petitioner vide communication dated 22nd April 2022 the reasoned order in compliance of the direction passed by the court in এগুলো সব দিয়ে দেবেন তো page 31 Stop. The reasoned order clearly mentions that the petitioner was found entitled to receive payment for the work purportedly executed. And same has been certified for payment by the concerned engineer of the corporation without any interest. Stop. The Controller of Finance, Vidhannagar Municipal Corporation, was directed to scrutinize all the bills. Stop. All the works in question are done with the fund received from the government of West Bengal through the Urban Development and the Municipal Affairs Department. Stop. The Joint Municipal Commissioner, Vidhannagar Municipal Corporation, was to communicate to the Department of Urban Development for immediate sanction and placement of fund for making payment to the petitioner for the works executed. Stop. The petitioner thereafter made representation before the
for us, not
Before the
government.
Corporation.
What is your instruction? Did you receive payment from
Lord,
the
payment has not been received, my lord, but we have communicated with the government apropos to the reasoned order.
আচ্ছা কি বললাম made representation before the Vidhannagar Municipal Corporation requesting releasing of funds. Stuff. Paragraph. The same has not been released till date. Stuff. Learned advocate representing the corporation submits upon instruction that requisition was forwarded to the Urban Development and Municipal Affairs Department, but fund has not been supplied. Stop. Learned advocate for the state respondents is not ready with proper instruction. Stop. The learned advocate for the state is directed to revert with instruction as to when the fund will be made available to the Bidhannagar Municipal Corporation for payment to the petitioner. Stop. A report from the Secretary, Urban Development and Municipal Affairs Department shall be placed before this court on the returnable date, 3rd of September. Service is taken on record.
My lord, state's notice, let it be.
Yes, yes, all notices taken on record.
recorded.
Lord, I appear for the KMDA.
Yes.
My father was the licensee in respect of a stall at the fish market, Lord. Lord, official licensing, Lord, agreement entered, possession certificate given. My Lord, my father died, leaving behind the widow mother and 2 sisters and myself. But they have already made prayer before the authority since the son was taking care of the entire family. Son is was with the father for long. He is having all the experience to run the business. So, Lord, nothing has been done.
Let the license be issued in his favor. This is your prayer.
Amongst the family members, it is
What is the stand of the authority?
My Lord, it appears from the
2017 to 24, who is running this stall?
yes, that's what I died in 2017. And
You are
this,
running.
Yes.
this at page 19,
Only source of bread and
at
butter.
page 19, the representation made, the request made for incorporating their name in
24.
2020. So 7 years, the authority will have to take all these.
Please come.
records.
You have not taken instruction. The petitioner seeks for transferring the license of stall number 56 in the Howrah Improvement Trust Fish Market.
Howrah Fish Market.
Acha, Howrah Fish Market.
Not improvement.
Initially, it was Howrah Improvement Fish Market.
Howrah Fish Market. In his favor. Stop. The fish license was issued in the name of Shaha and Company.
At page 16, position.
But nobody's name is mentioned. Why you want it to be transferred in your name?
Shah and
So Shah and Company can continue. Anybody?
Page 14, my father name Mohammad Khurshid Alam.
14 fishery license.
Everything.
This is Mr. Shah and Company director.
Company name. The proprietor is MD Khurshid Alam.
Yes, that is an internal matter between you and your family members. Shah and Company, the license remains because it's in the name of a company.
No, the difficulty is not in place of the name of my father since he is already no more in
So his name will be deleted.
And my name would be there. Normally they ask for the entire family members. The family members have already
license are not issued by the erstwhile HIT. This is the fishery license. They have obtained.
Assistant director. Where is the license by the?
That has not been annexed. That has not been annexed. Only the possession certificate at page 16 that has been annexed. At 14, what my learned friend is showing, they are Shah and Company. And Khurshid Alam is director as shown.
By the assistant director. Department of Fisheries. Now, by the assistant director of fisheries. In the name of Shah and Company.
Proprietor as a proprietor.
And the proprietor was
Khurshid Alam,
the father of the petitioner. Stop. A possession certificate by the Howrah Improvement Trust under the Urban Development Department was
now erstwhile HIT has merged with the KMD.
Was issued in favor of Shah and Company in the year 1997. Stop. The petitioner submits that his father expired on 6th May 2017. Stop. The petitioner prays for a direction upon the authority to record his name in place and instead of his father since deceased. Stop. The father of the petitioner has left behind his widow and other
Two daughters.
and two daughters, widow and two daughters. Stop. The petitioner claims that the other legal heirs of his father do not have any objection if the name of the petitioner is incorporated in the license. Stop. On a perusal of the writ petition, it appears that the other legal heirs of the deceased licensee of the deceased Khurshid Alam, Hazi Muhammad Khurshid Alam, have not been implemented as party respondents in the instant writ petition.
They have given later, not page 19.
Stop.
They
Paragraph.
herself not given later to the
The
authority for change of name.
prayer of the petitioner for incorporating his name is pending consideration before the Chief Executive Officer, KMDA. Stop. Paragraph. Without entering into the merit of the claim of the petitioner, the instant writ petition is disposed of by directing the Chief Executive Officer.
Instead of chief,
KMDA.
my lord, respondent was 6 be directed. He is in charge of
The officer on special duty
Yes.
and the executive officer, senior deputy secretary.
HIT wing. That is after.
HIT wing,
Yes.
KMDA, respondent number 6, is directed to take a decision on the prayer of the petitioner in accordance with law after giving reasonable opportunity of hearing to all the necessary parties. Stop. A reasoned order shall be passed and communicated to the parties. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Writ petition disposed.
No, since no affidavit.
What is the allegation?
Allegation, they are we
Only non-
Application in 2014 and he's come up in 2014. Next.
For the petition. Now, the petitioner is the principal of a college and he is praying for the freeze of the bank accounts because the accounts of the college has been freezed because of some unknown person who claimed to be the part of the college has wrote to the bank a letter for the freeze of the account. But the petitioner, being the principal, is the main authority and one of the signatories.
Was a similar writ petition moved earlier?
Similar writ petition, that was a society, and this is the college. And your lordship passed an order in that.
Show me that order. The writ petition was dismissed, if I am not wrong. Disposed.
Disposed of.
What was the direction passed?
And it passed to consider the representation of
Consider the representation.
petitioner.
অর্ডারটা নেই
মনে হচ্ছে।
Give the case number.
One 4436 of 2024. If your lordship kindly permits me, then I can. But the petitioner has also went to the appellate authority, which is the executive director in charge.
14436
2024. Executive director in charge, which is the body under the ombudsman scheme, which is page annexure P3, page 16. And but they have not responded, and that's why they have come before this honorable court.
Did you serve the ombudsman?
Yes, sir.
The notice of upgradation?
A notice of upgradation is not served, but we have served the state.
The state is not the answering respondent.
No.
Is the state the answering respondent? You want relief against the bank and you serve upgradation notice upon the state. So what is to be done?
Then I am served fresh and uncomplete.
And I will put this matter in the cold storage and it will not be heard for the next 1 year. What? There is a insertion in the list that you have to produce a notice of upgradation.
Yes, Your Lordship, we have produced, served the state. I greatly obliged, deeply obliged.
The same means that you have not served the proper respondent.
Yes.
Then what is to be done? The matter has been upgraded citing urgency. Stop. Notice of upgradation has not been served upon the respondent bank. Stop. Release the matter on 2nd September. Let notice be served upon the non-appearing respondent, intimating the next date of hearing. Affidavit of service is taken on record.
My application.
Yes.
The Lordship kindly peruse two documents. The petitioner is, my lord, widow, is the beneficiary of old age pension benefit. My lord, his pension was credited to the bank account, but that has been withheld by the bank.
Are you presenting the bank?
I am for the Somiti.
Somiti.
Respondent number 6.
Yes, this is the bank.
This is the bank?
Yes, absolutely.
Yes.
Your Lordship kindly peruse page 20.
Yes.
On several representation made to the authorities, district magistrate requested the BDO to look into the prayer of the petitioner so that he can get the benefit of old age pension. Next page.
Are you aware whether the money is credited in your account or not?
Absolutely.
Money is credited, but you cannot take it.
I have annexed the document.
All right.
Page 21, your Lordship kindly sees. This is block development officer wrote to the branch manager.
Let me hear.
Yes.
This is the petitioner and the petitioner's husband took loan.
Petitioner.
Substantial loan amount is there. We say after receiving the letter from the block development officer, we contacted her and also communicated the video that we shall release after deducting the loan amount. She is not coming. This is our communication.
How much is the loan amount?
Loan amount, her husband took loan 20,000 and petitioner 15,000. So 35,000 is there.
No, but then loan account from two different accounts, isn't it?
No, this account only.
Only one account.
One account.
How can it be?
How can the husband take loan from the wife's account?
For sergeant of her husband, that in the name of husband, the loan was sanctioned. That is the issue.
No, you tell me, can a third party get loan from somebody else's account?
That is self-help group is there. Most probably on the self-help group account. That is their self-help group is there.
No, but then the account is of the petitioner. The pension beneficiary is the petitioner. The bank account is of the petitioner. Then where from is the self-help group coming?
Petitioner took loan in the name of his husband. That
means the petitioner is the loanee.
Yes.
No. Then
my instruction,
how much is the money in the account?
One, the statement is there, as on 6th March 2025, 74,000 and odd.
Is due to you? Is the money due to you?
No.
How much is due?
That is the entire loan amount that was not deducted.
That means 74,000 is due.
It is credited to my account, this amount on old age pension.
That is credited to her account.
How much is due? 35,000 was the loan.
Yes.
Then interest will be there. How much is the amount?
Accumulating interest.
You make the calculation and release the payment.
Kindly.
She is getting the senior citizen pension and you are not releasing payment.
But we also requested the petitioner also to the meet. সেটা ভিডিওকে লিখেছে যে যাওয়ার পর
ভিডিওকে দিয়ে।
Then you should have communicated with the petitioner. Please come.
In my name, there is no loan. I repeatedly asked this question to my client. In her name, there is no loan.
Acha, the petitioner alleges that the third chair, Rajanagar Express Limited, is not releasing the old age pension that is being credited in her account. Stop. According to the respondent number 6, comma, the petitioner obtained loan from the account and has not repaid the same.
10,000 is the loan according to them.
No, no, another 20,000 is also there.
এখানে তো বলছেন তা না।
আরে কিছু লোন বলেছো।
The
ক্যালকুলেশন দিয়ে দেবে এটা।
the respondent number 6 has requested the petitioner to visit the office for settlement of the claim, but the petitioner has not turned up. Paragraph. No document has been placed by the learned advocate representing the respondent number 6 to show that the petitioner was directed to visit the office for a settlement. Stop. Paragraph there, it has been submitted that a sum of rupees 74,000 and odd is available in the account of the petitioner. Paragraph. The block development officer, Raninagar 2 development block, is directed to take necessary steps to ensure that the petitioner receives her old age pension in accordance with the scheme. Stop. The block development officer is directed to call for a hearing, is directed to grant an opportunity of hearing to the representative of the respondent number 6 and the petitioner and take necessary steps in this regard. Stop. The block development shall ensure that payment is released in favor of the petitioner positively within 4 weeks from the date of communication of this order disposed.
এটা আমি যাচ্ছি তাহলে আমি মোটে কি ভুল
May it please your lordship, my lord. I'm for the petition.
Yes.
Lord, this is my affidavit of service. Lord, the petitioner's form, my lord, happens to be distinguished and reputed in original.
Notice of upgradation.
Lord, where is the argument? My lord, I'm extremely sorry, my lord, what I have come to know, my lord, that this perhaps was not, my lord, the advent record has not given any upgradation notice. My lord, there is a bit urgency. I can understand. What can I do?
Repeating the same thing in each and every matter is impossible.
I understand, but I am simple.
And so that the court doesn't waste time, there is a
Without wasting your
note.
lordship's much time, my lord, I will only say, my lord, this is a case where your lordship will find initially what had happened, my lord, that I was debarred.
None represents the respondent. Stop. The matter was upgraded citing urgency. Stop. The notice of upgradation has not been produced before the court. Stop. Release the matter on 2nd September. Let notice be served upon the respondents, intimating the next date of
But may
hearing.
I take back the affidavit of service or it has to?
Yes. Take it back.
Or let it be on the record, my lord, because I will give a upgradation notice.
Yes.
My lord, kindly records that, my lord. Any.
Affidavit of service is taken on record, but then these copies I will not keep.
These are refused. Good service in
Yes.
law, as your lordship knows.
Very well. The 3 envelopes have been filed before this court.
Refused and unclaimed.
Which have been refused to be accepted by the respondent numbers.
Lord, this is 6 8 and 9.
6, 8, and 9. Stop. The learned advocate on record of the petitioner is directed to open the envelopes and take back the unserved writ petitions. The unserved envelope shall remain on record.
I'm so grateful. I'm so grateful. Deeply upgradation notice to the grateful.
Well, I am for the petitioner.
Yes.
Well, this is with regard to the non-payment of compensation due to death by tiger attack. Well, page 24 is the report. Covered by your earlier
Page
lot.
24.
24. Well, the body could not be.
Petitioner is Kobita Mondal. Dhananjay Mondal is the
Yes.
person who has expired due to tiger attack. Incident took place. Where is the PM report?
No, body could not be found. 24, page 24. It's saying that it says died due to tiger attack on such and such.
Give me the order that has been
Right,
passed.
right.
Two similar orders were passed by.
Yes.
অনিকেত অর্ডার একটা দেখি অর্ডার দেখা
Same.
Do you? Acha. The fact is the only that the body was carried away by the tiger. The child did থাকছে. Do you have a report with you?
I have
No,
nothing left.
দরকার নেই এটাকে কেটে দেবেন রিপোর্ট বাই এটাকে কেটে দিচ্ছি এই ইস্যুটা এটা থাকছে এটা থাকছে এটা থাকছে এটা থাকছে
বলেছিলাম মানে কালকে বা আজকে থাকতে হবে আজকে আমরা পেন্ডিং আছে
হ্যাঁ এটা তো স্কিম মেমো ইজ দ্য সেম
ফেব্রুয়ারি মার্চ মাসের বোধহয় মামলা
The report of the police dated 18th May 2017 mentions that এর পরে একটু লিখুন তো that the incident took place inside Sundarban Tiger Reserve as per report of the range officer, Shojnekhali Wildlife Sanctuary Range. And it is clearly mentioned that that's Dhananjay Mondal, husband of the petitioner, died due to tiger attack on 13th August 2016.
কি নাম আছে হয়ে গেছে
Respondent number 2.
রিপোর্ট কই রিপোর্ট কোথায় কোথায় আছে সেটা ব্যাগে রাখি এখানে রাখিস কি জানো
ঠিকই আছে deceased নামটা বসবে এখানে ধনঞ্জয় মন্ডল JAY আছে একটু দেখে নেবেন অন্য জায়গায় মন্ডলেতে DOL আছে
Great.
You hold a camp over there because this is very much required and this is not a joke.
Well,
I really mean it.
Well, some of the NGOs are holding camps.
Yes.
But unfortunately, Lordship sees the timeline. Many of the families do not have any documents to substantiate their claim. Therefore, they are unable to come before.
Police report and nothing.
Nothing. Because my lord of the Amphan and Ayla and everything.
So Amphan and Ayla is long ago.
No.
There may be recent cases also of
recent
tiger attacks.
cases, my lord, we are bringing to your lordship. Several are still
This
pending.
is also 2016 matter.
Some new cases, it's also pending in your monthly list, my lord. My junior has mentioned them.
Please mention so that these can be disposed of.
My lord, I'll be grateful.
All right. Now I have to make a heading. Tiger attacks.
Like payment of dues.
Because, my lord,
It's a new heading.
for these families, this amount is life changing.
Right. I understand.
I'm grateful. My lord.
Next.
My lord, I'm here for the petitioner. May I please your lord? My lord, this is
I am being for one of the private respondent. I have not
kindly
been
on
served.
that side.
I have not been served, my lord, with the copy. Even I could not find it in the Sharthak also, my lord. My client is in Bombay. I have only received a mail and a vakalatnama from mail, my lord.
Why did you
My
not
lord,
find
this has returned
service to the
unclaimed.
public prosecutor? You serve the state through the public prosecutor? What type of a drafting is this?
There is no writ petition in the Sharthak, my lord. I could not find it.
Who will be the answering respondent?
Why not state? Why not state? My lord,
You are busy talking to the learned advocate when the court is
my lord,
questioning
pardon,
something.
my lord. I haven't seen the arraignment of the parties.
Why? You should have.
My lord, I'll make corrections and amendments. My lord, the predicament, my lord, just one, if 1 minute may be allowed.
1 minute, your writ petition is not in form. It
My
is
lord,
dismissed.
I'll rectify. I'll rectify the implement of parties. Insofar as a private respondent is here, it has come unclaimed. And I am also with the affidavit of service on that.
Yes.
Affidavit of service.
If your grievance is against the private respondent, go before the forum.
My lord, I'm not against the private respondent.
When suit is pending, I have obtained an
My
offer
lord,
to
kindly,
Salt Lake property, my lord.
if this is going to be contested by the private respondent, then it is one.
Will be contested.
I will definitely make corrections to the arraignment of parties. I'm not on that, my lord. It is a mistake. I take it. And I apologize for that unconditionally. It will be rectified, my lord, with your kind leave. But my lord, kindly come to the nature of the order. That is an issue.
Passed by whom? Public prosecutor?
No, passed by the learned executive magistrate, my lord.
Where is the against challenging order of the executive magistrate?
I'm not here before the challenging the order of the executive magistrate.
What are you challenging?
I'm challenging the fact that I am remediless before the revisional court right now. I have challenged the order of the learned executive magistrate before the revisional court. The executive magistrate has directed in 107, while exercising jurisdiction under 107, for giving access and installation of CCTV cameras against the consent of the other co-owner, who are senior citizens. They have been driven out of the home. They have preferred a revision.
And why do you say that you are remediless?
Because the revision was filed back in August 2024.
Yes.
There was no order of stay passed. Call for record was done under 397 CRPC.
Yes.
However, it is pending as on date, and the next date is fixed on November.
And so you'll file a writ petition?
My lord, I am remediless. My
Sir,
fundamental.
You are not remediless. If your matter is pending, you mention it, get it done.
My lord, we have done so, and the practice, that is why we have also annexed the certified copies of the order sheet.
No, but then I do not see any reason
I am not claiming that
for filing the writ petition.
My lord, the fact remains that today, even though there is alternative remedy, the alternative remedy is not efficacious.
That is not the alternative remedy. That is the statutory remedy that you have to avail.
I have availed.
It is not alternate. That is the only
and the
remedy.
statutory remedy, that remedy has now been not being efficacious. I've been not given that.
Sir, you have a private dispute with your private respondent. It's all right. There are forum taking up the private dispute matters. How is the writ petition maintainable? Where is the state authorities in action?
My lord, the jurisdiction of the revisional court, it is enjoying the
Interim or injunction order is with me, if your lordship wants to.
Civil court's injunction order, and the fact remains here is that there has been a mandate. There has been a mandatory nature order which has been passed by 107 court directing the installation of CCTV cameras, my lord.
That order is
My lord, that has been
simply
challenged. And for a year and more, I have been rendered remediless and I have been forced to go out of the house.
You are taking it upon yourself that you are remediless when you are actually not.
We have mentioned it time and again before the revisional
Is
court.
that a ground to file a writ petition?
My lord, what will a litigant do if the statutory revision, statutory remedy?
Show me the revision.
My lord, kindly come to page number 51. This was as on the date this writ petition was filed. So if my lordship sees, the filing was done on 29/8/2024.
All right.
And since then,
Why
my
did
lord,
you approach the criminal revisional jurisdiction to get an
my lord, the
order?
only predicament is, only reservation I have is the criminal revisional jurisdiction are concurrent, my lord, in so far as the High Court and the Session Court are concerned under the CRPC. In such, maybe 227 may only be the appropriate.
227 will be the appropriate.
And
You
this
go
can
there.
be converted to 227 in that so case.
If
My
you-
lord, if so directs.
I can
My lord,
permit
my lord.
direction. Please come. The petitioner seeks a direction upon the learned second additional sessions judge at Barasat, North 24 Parganas, for early disposal of a criminal revision application which is pending consideration since date of filing, you say, is? What is the date of filing of the application? Date of filing of the application, page 51. When did you file it?
My lord, the revisional application
Yes.
was filed of 29th of August 2024. And it is evident from page number 51 of the order sheet. The annexure P13. Annexure 52.
My lord, will kindly take that note of the service, my lord. No address has been given.
1 minute. 29th August 2024. Stop. Next. On a perusal of the cause title of the writ petition, it appears that the same is not in form. Stop. Paragraph. Liberty is granted to the learned advocate on record of the petitioner to amend the description of the respondent number 1. Stop. Next. The court is of the opinion that the matter cannot be taken up for consideration under Article 226 of the Constitution of India. Stop. The petitioner prays for a direction for conversion of the writ petition to a criminal revision application. Stop. Paragraph. Learned advocate representing the respondent number 2 submits that the copy of the writ petition has not been served.
Service has been, my lord, will kindly note once, my lord.
What
No
address?
address has been given. No address. Lord will kindly see, my lord, how it is served. My lord, Salt Lake, Calcutta 64. And my lord, the address is CV 189.
See?
Well, I don't know, my lord, how.
No, this
And my
will
lord,
be-
my
this
client
will
doesn't
be
reside over there.
come
He
back.
knows
Hey,
that.
are you there?
Well, I am appearing.
All right.
I am with the envelope and
the-
intact.
Has not been served. Stop. From the affidavit of service that has been filed in court.
Affidavit of service, sir.
Now, from
That
the,
affidavit of service,
from
sir.
the speed post
Should have been annexed
receipt
with the service.
annexed to the affidavit of service at page 7, it appears that the same was not properly addressed. Stuff. However, copy of the writ petition, which was sought to be served upon the private respondent, but has returned unserved is being opened from the unserved envelope and handed over to the learned advocate representing the private respondent in court today. Stop. The unserved envelope is retained with the records. Stop. The department is directed to convert the instant writ petition to an application under Article 227 of the Constitution of India within bracket criminal. Next.
My lord, obliged.
My lord, item number 35, ma'am, for the petitioner. My lord, Mr. Kollol Basu is engaged in this matter. My lord, I'm praying for a not today because of his absence today.
I'll
I am ready with the matter otherwise.
Please. Where is the notice of upgradation?
My lord, my phone has died. It's in the email. The actual notice of the email is with.
I do not want explanation. I want to see the notice.
Right now, my lord, my phone has died. Otherwise, my lord, kindly gives me
The
one day.
matter was upgraded citing urgency. Stop. The notice of upgradation is not placed before the court. None appears on behalf of the respondents.
Kindly gives me one day, my lord. I have
Lift
served.
on 2nd September. Service in the meantime. Next.
36, I appear on behalf of the petitioner.
Yes.
This is a change brief. I have served notice. My learned friend is appearing.
Yes.
Now, matter in earlier litigation, it was sent to the adjudicator by an order of this honorable coordinate bench. Now, this is a relation to equal pay for equal work of Krishi Vikas Shilpo Kendro. This was formed. This is an organization registered in the Department of Land and Land Defense Department. Now, central government in 1975 formulated a scheme for development in the agriculture and rural development. On the basis of this was organized and continuing there. PMO office, Prime Minister office, repeatedly sent letter to the Chief Secretary, to the department of the concern, saying that do something for this person, but these people, because they are working there and their work is satisfactory.
Please show me this order dated 24th of June 24.
Not 23 order.
24th June 2024. Reasoned order which is under challenge.
Yes. But this is under challenge. This is at page 84. Now, this page 84, here a writ petition was referred to the honorable to the execute the adjudicator. Similarly, this order, but kindly come page 88. Page 88. First paragraph.
Yes.
It is also felt necessary to examine the document or GO of the 20-point program to check the status of workers engaged in implementation of 20 points program. So he is opined that these documents or GO is to be verified or is to be seen into. And both the parties, here party means the petitioner as well as the government of West Bengal Land Department. If that is available at page 84. Agriculture department are also up there. Now, what he has said, as both the parties have failed to produce the documents or GO of the 20-point program, it is not possible for the adjudication to make any comment on the aforesaid issue. So he says these are the documents are required. These are the document of the departmental document. In one way, he says this is to be ascertained. On the other hand, he rejected.
You have a claim. Yes. The claim must be based on documents. Will you not produce the documents before the authority?
I have produced so many documents. If your lordship kindly come peruse, and he has rejected. So my respective submission is this: if your lordship remand back the authority,
certainly not.
Then your lordships kindly come. But I have, if your lordships at page.
You file your opposition. This cannot be done.
Instead of opposition.
Only thing is this 20-point program is offered
in the nature of a directory of the central government. So
Not mandatory,
not
it's a
mandatory,
directory.
it's directory.
Oh, you disclose everything in your opposition? আচ্ছা লিখুন তো the order, the recent order dated 24th June, the recent order.
I would
dated
rather say it's an
24th
advisory, not even directory.
advisory.
It is only an advisory.
The order dated 24, হ্যাঁ 24 June 24, passed by the additional chief secretary, WRI and D department and adjudicator in compliance of the direction passed by the court in WPA 12130 of 2018. Abdul Wahad and another versus the state of West Bengal and others is impugned in the instant writ petition. Stop. The writ petition cannot be decided without exchange of affidavits. Stop. 6 weeks, 2 weeks. Divided to mention.
As you lost.
Because petitioner's minor sought his intent to participate in a regional level boxing competition at Alipurduar, my lord, but he was denied. Therefore, my lord, we have filed this writ petition on yesterday, my lord.
When is the competition going to be held?
16 and 17, my lord.
Of this month? Where is the time to adjudicate? Today we are over with the 13th. Tomorrow is the only working day prior to the 16th. How can it be done?
No, only we are seeking permission, order, my lord, to participate.
Denied? That means there must be some reason for denying it.
Reason is this, my lord, that there is no zonal level competition held at Howrah.
Yes.
My lord, there was no zonal level competition organized in Howrah. Therefore,
So if the zonal level competition is not there, how can the district level,
regional level,
regional level, how can he participate?
This year he also participated in a zonal level competition, my lord, but not in Howrah. This is the only.
He participated in some other zone.
Some other zone. And on a school, various school level competition, he has participated and win gold medal, etc.
Listen, your medals will not do. Thing is whether you are entitled to participate or not, because your entitlement has been challenged.
Yes.
Did you serve upon the
I have
authority?
served upon email, my lord.
Who is the authority?
My lord, I have served the schools, respective school, ICSC council, West Bengal ICSC council.
Who has refused? Refusal by whom? Who is holding the competition? Is the writ petition maintainable?
Holding the competition is a school, my lord.
The school, how can the writ petition be maintainable?
My lord, actually the affiliation is given by the Kalimpong District Boxing Association. It is the state under Article 12.
Then Kalimpong matter, how can it be taken up over here? It will go before the circuit bench. This matter cannot be taken up under any circumstances over here. You should have rushed to the circuit over there.
Your petitioner residing in Howrah.
That will not be a reason. Sorry. This time, opportunity gone. Next time you see.